Started. Ms. Maxwell, would you please call the roll?
We're going to do the public disclaimer first.
Should I do the
Oh,
note?
let's go. I thought we'd change it up a little bit, but if you want to do your public disclaimer first, go ahead.
Okay. Notice of the February 4th, 2020 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 30th, 2019. Additionally, this month's agenda has been posted on the website since Friday, January 31st, 2020.
Thank you. Al, would you mind calling the roll?
Yes. Commissioner Jeff Diaz,
Present.
Commissioner Joe Begley,
Present.
Commissioner Marcia Franks,
Here.
Commissioner John Moffitt, Commissioner Stacy Torbett, Commissioner Bobby Wood,
Here.
Chairman John Grease.
Here.
You have a quorum.
So at this point, it might be a good time for you to mention that we do have a new commissioner that's coming on board next month.
Yes, there was a new commissioner appointed yesterday. His name is Steve Gwynn. He is out of Memphis. And it seemed a little too soon to get him here today with all of the items that need to be filed, such as the oath and orientation, but he will hopefully be here at the March meeting.
And he's finishing Fontaine's unexpired term.
That's correct.
So it's a short appointment, but then obviously he's available to be reappointed.
Correct.
All right. At this point, I'm going to ask Commissioner Bobby Wood to lead us in a prayer, and then following that prayer, if you all will stand, we'll pledge to the flag. Mr. Wood.
Bow with me. Our most gracious Heavenly Father, we just thank you for the opportunity to be here today, and just thank you for giving us all safe travels. We come in and just ask you to guide us today throughout the course of our meetings, and just be with us as we do the things that you've appointed us to do. These things we ask in your name. Amen.
And
I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
thank you, Commissioner Wood. Next up is to approve today's agenda.
I wanted to add one thing.
All right.
And it may be on here, and it doesn't need to be added, but we are discussing the rule change. Are we discussing the rule change today?
I don't think so.
The one that was already voted?
There was two in the minutes. There was,
The one that you guys voted on has started the process of being sent,
okay.
It has to go through department channels.
Maybe I just was wondering about the status of it then.
Yeah.
Okay, then I make a motion that we approve the agenda as written.
Second.
Okay, the motion is made by
Go ahead. I had a
Ms.
couple
Franks,
changes, but
second
go ahead.
by Mr. Diaz. So it's properly on the floor. Now, Mr. Wood.
I just had a couple things that I think maybe need to be clarified. One thing, under the executive director's report, we talked about the attorney general request, and what it reads, the commission wanted to.
So stand by on that.
Okay.
We got approved in last month's minutes, and that's where that shows up.
What are we talking about?
The agenda today.
Oh,
So
I'm just ahead of you about
I know you
5
are.
minutes.
You-
Okay,
you're
my
always ahead of
bad.
us.
My bad.
All right, so the motion on the floor is to approve the agenda as presented. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, vote no. That motion passes unanimously. And for the record, the chair is going to end this meeting no later than 1:30 today, okay? So if we don't finish everything by 1:30, it'll carry forward to the next month's meeting. I don't think that will be the case, but just for planning purposes, 1:30. So fine. All right, next up is to approve the minutes of last month. Mr. Wood.
Okay. Under the executive director's report, it said attorney general request. It reads, the commission wanted to know the clarification of disbursement of commissions from the AG's office in regards to title companies paying commissions at closing. I think it probably should, the issue has to do with 62-13-312B11. And I don't know that it's necessarily just about title companies, because in that that rule, I mean, that law, it says, accepting a commission or any valuable consideration by an affiliate broker for the performance of any act specified in this chapter from any person except the licensed real estate broker with whom the licensee is affiliated. It goes on to say, we can only get compensated from your licensed real estate broker. And that was really the question, is that what is meant? And does that mean other people, that the broker can tell other people to pay it or something? It's not just
So the question is physically hand the check, or can the broker give permission to
or does it have
anyone
to-
else
or
to
to-
distribute the
Or
checks?
how would the Attorney General clarify that the broker's not paying them? Does it have to come from the broker's account, or does it mean what it is, the broker's got to pay them?
So you want the minutes to reflect the statute that we're talking about?
Exactly,
Or the
exactly.
law that we're talking about?
Yeah.
6213, 312B11.
I think it was more broader than we're just picking at title companies.
Okay, so could you clarify can the broker, that question again?
Well, what the law says, that our compensation has to come from licensed real estate brokers, from the licensed real estate broker. And I guess the question is, can the broker then tell somebody else to do the compensating for them? Even to the point it's not even directly coming out of their account.
So more asking if the broker can delegate
Yeah.
paying commissions out to another party?
Because here's what the argument's going to be. The broker is sending their money to that title company, but actually, I think the title company is taking it out. I don't think it's going through the books, is what I'm trying to say.
I don't know, but I can read that statute, it's pretty black and white, but it's not being interpreted as black and white in the marketplace right
That's right,
now.
that's right.
So that's what we're trying to, so you want do you have language for the minutes, or you just want to make sure the intent you just talked about is included?
I think the big thing is, we're talking about that law right there,
Okay.
that statute.
We can clarify
And
that
I mean, and
section.
other than like John was saying, I mean, we're reading it black and white,
Mm-hmm.
that what it says is what it says, and is the Attorney General have a different interpretation for us? Because I think we can only go by what the law says.
So we will clarify that section and make sure it's clarified for the AG.
When you do that, will you just send it to Bobby, just so he take a look at it, just to make sure
Sure, yeah.
he's got what he wants? Other comments about last month's minutes?
There was one place in the executive director's report under February meeting where it said, welcome to participate in the TAR, Tennessee Association of Realtors Day on the Hill. So being Fontaine here. So it's not TAR, it's TR, the Tennessee Realtors, not Tennessee Association of Realtors. And it's not actually the Day on the Hill. It's the Tennessee Excel Summit. Just for clarification.
Thank you.
And realtors should always be in all caps.
Thank you, Fontaine.
You might be watching.
Yeah. All right, other changes? I do have one change I would like to suggest. In the discussion where it talked about rule changes, in particular business cards, the way it's written is not at all clear in my opinion. It says a motion to approve adding business cards to the advertising rules was voted and denied with a roll call vote of 5-2, as Commissioner Wood and Chairman voted against. Well, actually, the
Opposite.
motion failed on a 2-5 vote, with Grease and Wood voting for.
Because the
It was a positive.
cards are already in the advertising
It was a
rules.
positive motion, so the motion was to add business cards to the advertising rules.
No, the cards are not in advertising.
They're not now, but the motion was to
Yeah.
add them.
Add
to
them
them.
was
Yeah.
the motion.
And so that motion failed on a 2 aye, 5 no vote. So Grease and Woods voted for the motion.
We can get that clarified.
Got it. I just want to point that out. Okay, other comments about last month's minutes?
Motion approved as amended?
Motion by Mr. Diaz, seconded by Mr. Bagley, that last month's minutes be approved as amended. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you all. Next up is a request for a medical waiver from Jeffrey Gade. Gad or Gade?
Yes, Jeffrey Gade. This is one that had previously come up, I think, a couple months ago, and has now met all requirements in order to go. He would like to renew and retire his license. So he's asking for a waiver of $600 for the late fee. All of the requirements have now been met, and you can see a physician statement and a letter from Mr. Gadd on your iPad.
And if you'll remember, this is the one who had a stroke. And for that reason, my father has had a stroke, and I understand how debilitating that is. And for that reason, I'd like to make a motion that we approve Jeffrey Gade's medical waiver.
Second.
All right, we have a motion by Ms. Frank, seconded by Mr. Diaz, that the request be granted to Mr. Gade. Discussion. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Next up is Mr. E. Ross White, Education Director's Report.
Thank you, Mr. Chairman, members of the commission. Good morning.
Good morning.
I call your attention today to the education agenda of February 4th, 2020. I have reviewed the providers, the courses, and the instructors, noted J1 through J16.
All right, let's take the courses first. Is there a motion to accept the Education Director's recommendation and approve courses J1 through J16?
May I ask one question first?
Let's get it on. Let's get it
So
on.
moved.
Okay.
Second.
Okay, motion's on the floor by Mr. Diaz, seconded by Mr. Wood. Now, Ms. Franks.
On J3 and 4, that was the active shooter and the drug identification awareness courses.
Yes, ma'am.
And Mr. Ken Poteet.
Do you want to pull those out?
Pull it out.
Okay, let's take J3 and J4 out of the motion. Any other courses anybody wants to take out, Bobby? All right, let's vote on courses J1 through J16 with the exception of J3 and J4. Those in favor of the motion vote aye.
Aye.
Those opposed vote no. Motion passes unanimously. Before I get to you, Mr. White, just out of curiosity, why is the letter J in front of these courses?
That's what I thought too. Like June or
Since
July
it's February.
or January.
That is my error. It should be at F for February. So noted, it should be F1 through F16. My mind, as I was preparing this, of course, was still in the month of January, but it is the F1 through F16. So
Without objection, let the motion reflect it showed F1 through F16, with the exceptions of F3 and F4. Now, Ms. Franks, F3 and F4.
So I'm wondering about Mr. Poteet's. These are new classes, and I'm not saying that they're not important, but I'm wondering about his qualifications to lead these classes. Can you tell me a little bit about?
Mr. Poteet has submitted to us before, and the awareness group actually has been a provider for some time. So, yes, his background is in law enforcement and in training, of course, along these lines for self-defense, and again, for drug identification awareness. So he does have the credentials to do this, and he has done it before.
Okay.
So this is not new.
Since he's not a new instructor, so I had no idea of what his qualifications were for that class. So I just those are such important topics. I would certainly want an expert to be able to direct those classes. So with that, I'll ask that we approve F3 and 4.
Second.
Okay, the motion by Ms. Franks, seconded by Mr. Diaz. Motion is to approve courses F3 and F4. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Next, instructors, Mr. White. We got 3 or 4 here. You want?
Yes, Mr. Chairman, we have 3 new instructors we'd like to bring to your attention today. Ask for your approval.
Motion to approve these instructors.
Second?
Okay, Mr. Diaz makes a motion, and Ms. Frank seconds to accept the Education Director's recommendation and approve the instructors listed in the report. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, Ms. Maxwell,
I was going to see if we could take a very quick break. Somebody's parked in the wrong parking spot, and
one of us?
Uh-huh.
Okay, what is it, what kind of car are they driving?
Marcia.
I parked her there. I told her she could park there.
Okay, well,
The man wasn't out there.
yes, I know. I'm sorry. Apparently, you were parked in a VIP spot.
Well, then that's the right
That
place.
works, that's perfect.
So they want me to go move my,
Another VIP.
more VIP than me.
That's not possible. You're President Borrello. Let's talk about that.
Maybe y'all can keep going. Oh, no, you have to have me, don't you?
Let's take a pause.
He wasn't there when I was there.
You weren't there when I was there.
Nope. But I parked.
All right, we're taking a short break. All right, we're back in session. And we're going to go to the Executive Director's Report.
Thank you. Sorry about that.
Not your fault, it's some selfish somebody that caused us to take that delay.
So, the main item that I wanted to get the commission to consider today is the mid-year Arillo meeting. It is April 29th through May 2nd. We could potentially wait until March, but it's probably a good idea for us to go ahead and get the approvals going on that.
So, where is it?
It's in Savannah, Georgia. And that's a Wednesday through a Saturday.
429.
So, Ms. Franks, who's the president of Borrello, is already going to be there, so we can take at least a couple more commissioners.
Right, yes.
All right, so, Bobby, you interested? Can you go?
Mike could.
Well, what about Jeff? You were on and then you had to cancel.
On, and I had to cancel.
You want
yes,
to
sir.
go?
I would like to try, yes, sir.
Joe?
Sounds. There's space. I'll try to. There's space. I'll try to go.
Well, let's Marcia, why don't you make a motion that Bobby and Jeff be our delegates and Joe be our backup in case one of the two can't go.
Okay, I'll make that motion that Bobby Wood and Jeff Diaz go to Arillo April 29th through May 2nd. And if one of them is unable to attend, that Joe Begley take their place.
And alternatively, I would think if we can somehow finagle 3 to go, that Joe would be on that list. What do you think about that? Do you think that's a
I
possibility?
think it's a long shot.
Spend the money.
Yeah,
We gotta spend the money.
talk.
I mean, what better place to spend our money than helping the commissioners become better commissioners, so.
You're correct. All right, let's vote on the motion. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you, Ms. Franks. Will you be making a presentation? Can they come and listen to you speak? Not that they don't get to hear you enough here, but I mean,
It's not that I'm making presentations, but I'll have to attend every single committee meeting, so
they can just follow you around it.
if they want, they can.
Mr. Chairman, is the staff be joining us on this trip this time?
Caitlin's going, Anna's going. Ross, do you get to go on these things anymore?
Yeah.
Okay, good.
And I just was in Key West, Florida, for our leadership symposium, and we completed our 3-year strategic plan. And there's a lot of good things on there. There's so many ways that Arillo can be helping commissioners. I know our inspectors, we don't even know who they are, but there's a lot of good things for that. We're also have a new timeshare a media campaign that's about to start, because as you can see from today's docket, how many timeshare problems that we're having in the state of Tennessee. It's happening nationwide, worldwide actually. And so there's a lot of good information for that. And I would love if we had some sort of representation at that timeshare committee meeting, because it's going to be a really important meeting.
So since you brought that up, I have a question for legal. So I'm sure you share the same sense that a lot of the timeshare complaints we're getting are from these people that are advertising they get you out of your timeshare. Here's just a thought. When you send them a letter back that says the commission can't help you because the 2 years, the statute of limitations has already passed, I would, if you could include in that letter, ask them who helped them try to get this complaint through, so we can get the names of those companies that are advising people, and at the very least, send those companies a letter saying, just so you're on notice, if it's over 2 years, the statute of limitations says there's no complaint to be filed, just to try to maybe shortstop some of these. Is that something we could do?
So the letter that goes out when complaints are closed, we don't send that letter. That's a letter that's sent by our centralized complaints division. It's pretty generic letter. It's a form that says that the complaint has been dismissed. I'm not sure if we know. Sometimes when we get timeshare complaints, it'll be filed by the individual. Sometimes it'll be by another company, or sometimes it'll be by a company we don't know that they're filing on behalf of the individual. So it might be a little tricky, especially since we don't have jurisdiction over timeshare exit companies. But we have had conversations with some of the timeshare companies that have let us know of some of the individuals and some of the exit companies to be aware of. So we can better spot those issues.
That's also something that you can find through Arello. The media campaign that I was talking about, there's 2 different people that are being interviewed in it, and people are paying from $10,000 to $30,000 to get out of these timeshares. I did learn, and I'll send it to you, Anna, there is one company that does it for $800, and what they actually do is they tell you how to do it yourself instead of having to pay. But, people are paying that large amount of money because, they're going to be out, even more than that if they continue on. So it's a whole there's companies that do nothing but charge that, and then they don't get them out of it.
Well, and they know the law, or I think at least if Consumer Affairs or the Real Estate Commission, someone puts them on notice that says, hey, if they bought it more than 2 years ago, you can't help them regardless of what the story might be because of statute of limitations. At least they're put on notice.
Right, that might be like a conversation that we need to have with other individuals in the administration, whether we want to do some kind of communications to consumers so they're aware of the timeshare companies and the statute of limitations. But also what I'm hearing is we might need input from other entities that would have more jurisdiction over this, because this specific issue falls outside of the commission, but also the Consumer Affairs Division has moved back to the Attorney General's office, so it's no longer housed in the Department of Commerce and Insurance. So we can definitely see what we need to do to have those conversations so we can let people be more aware.
I will tell you that, like the National Association of Realtors, who's running national commercials, it's Arello. We're going to be running these commercials nationally. And it's going to be telling people what to do and what not to do. So I would love to have the support of the state in this, trying to save our consumers and protecting them.
So I think back to former Commissioner Julie McPeak, who was doing PSAs all the time, smoke detectors, whatever. But to me, maybe somebody in the Department of Commerce and Insurance, or somebody from the Attorney General's office, if that's where Consumer Affairs is now, could do some PSAs that say, beware of companies who say they can get you out of your timeshare, because a lot of them are just going to take your money and run.
We could even do something with our, there's a whole media division of Commerce and Insurance that could at least do a couple quick items to make people aware of the statute of limitations.
That's a big deal. People pay a couple $1,000 to try to get out of a deal, and it's not even possible from the get-go because the statute of limitations.
Well, and I
is in
thought it was
play.
a couple of $1,000, but 10 to 30,000 is more than a couple of $1,000. I didn't realize how awful it was.
Anyhow, that was my thought for the day.
Could there any way be, when people are filling out the complaint form, especially if they're doing it online, does it ask, is this about, timeshare, or if they say it's timeshare, could it then, right then, say, were you aware there's a 2-year statute of limitation, and just kind of nip it right there?
So the complaint form for everyone it's a generic form. So it goes across all of our boards and entities, and it just asks for specific information. And then once they fill it out, it's filtered to the Real Estate Commission. I don't know necessarily if the 2-year statute of limitations question would help, because even if they were to file a complaint, we still have to process it and bring it before the commission. We can't just automatically close it out. And also, if it's a company like that, or because at the end of the day, timeshare exit companies are basically scam companies, as we know. So they're probably not going to care much about the 2-year statute of limitations, or also believe that they're exempt from this 2-year statute of limitations. But we've been talking about other ways to possibly revamp the complaint form, so I can take that under consideration.
That would be a good discussion in that timeshare committee at Arello, too, to say what are other states doing, because it's a problem everywhere.
See, I just think myself, if I had bought a timeshare and then hired somebody for $5,000 to get me out of it, and it comes to the Real Estate Commission and legal says we can't handle it because it's more than 2 years, it's past the statute of limitations, I'm going to be ticked off at the company that I paid $5,000 to for not knowing that or not telling me that up front. So at the very least, if the state in some form or fashion puts these companies on notice that there's a statute of limitation that applies to getting out of a timeshare unit, they might have a basis or a better basis to sue that exit company if they so chose to do it, just because we've helped document.
For instance, it could be required to be in the documents, the contractual documents of the timeshares. So they could at least say, look, they signed it, or they were told, or, for the ones who do read them, at least they would be put on notice. That would be a simple thing to just require it.
Both of the people read it. They sign it, but they don't read it. Anyhow, just for discussion. All right, Caitlin, the rest of your report?
That's primarily what I wanted to update the commission on. We are making some changes to our forms. You might see a new Trek One form that has been rolled out. It was somewhat time for an update, but also now that we've had a change in the fees, the form was outdated. So we updated it to reflect the fee changes, and hopefully the goal is to get people to completely fill out the form, which has been an issue in the past.
Would you mention the number of people that just had their license revoked?
Yes. So per the statute, anyone that has had E&O insurance expired since last January 31st is now in a revoked status. So
What?
revoked.
Okay.
So we worked with legal, and we basically just followed exactly what the statute said. And so as of Friday, they're in a revoked status, and we have sent letters to the licensee at their main address, and if they're still at a firm, at the firm address, and then also to their principal broker. A lot of those people, though, are not with the firm. Their principal broker went through with releasing them. So it wasn't the whole group that also got a letter to the principal broker.
But you failed to mention how many
The
people,
number.
how many licenses were revoked,
The little,
approximately.
I can give you an exact number in just a minute, but I believe it's in the 300-ish range.
Which is much better than last year, because last year we had whole companies that had a problem.
Yes, so.
Has that been cleared up? We don't have any whole companies?
No, sometimes the people that all expire on January 1st, 2019 are not the main group that we have the issue with, because that's the state insured group, and we kind of have that down to a system of how they notify us and we upload it in our system. The problem is that sometimes when there is a firm policy, the individual licensee doesn't know to give us that policy. That's kind of where we run into the issue. But anybody that is revoked in error, we always correct it.
But there wasn't, like, last year it was Crylike. Crylike had a huge, because I think they don't go through the state insurance.
Yes.
So was that resolved? We didn't have that problem with them this year? This time?
So this is not people that have recently expired. It's people that have been expired for over a year.
Oh, okay,
So they have been without E&O insurance since
okay.
this time last year. But yes, we have been working with a couple of those groups, making sure that they know where to file the insurance. The easiest way to do it is on a spreadsheet so that we can upload all their policies at once.
So I asked Caitlin, and I think it'd be good, if the names of each of those 300-plus people show up in the disciplinary action report as revoked for failure to maintain or to secure errors and omissions insurance, and you think that's going to happen?
In order to show, and I'll have legal correct me if I'm wrong, in order for them to show up, they would need to actually comply with the discipline. Is that correct?
I don't know. I can get that answer for you. I'm unsure.
But typically, when we revoke a license, it'll show up in the DAR report, and that's what we're doing.
Right, I'll just double check. I want to double check and see if something that happens that's like that doesn't stem directly from a complaint goes on the disciplinary action report. But I will double check with people by Macy what we can do about it.
Because there's probably nothing more important that, as a practitioner, that you need to know more than who's revoked, so that you're not dealing with someone who's revoked.
And why they're revoked.
Another thing that we're working on is, right now we get a lot of people that pay for their renewal and they don't have E&O insurance, or they don't have their education yet. And so I'm trying to work with IT right now to, at all links, prevent people from doing that, because I think it does give some people false hope that they paid for their renewal and they think they're good. So at the very least, we're hoping to use it as a deterrent and communicate, again, the requirements.
Okay, what else?
I had a question. You said last time that you were getting the welcome letters and that
Yes.
you had it ready for the brokers. And you said that you were working on getting approval for the affiliates. Were you able to get that approval for the affiliate letters?
So kind of the way it works is we draft the language, I review it, we make changes back and forth, and we then have legal approve it, and then we get it to our IT department, test it a couple times, because the formatting can change once it's in the system. So it's still in that process, but the brokers have already gone through.
I also thought it was interesting, too, about the amount of failures this past month, too. There were a lot of, on the licensure, there was,
National test for Tennessee.
yeah.
Less than half.
On the affiliate broker,
Under the, I think it was brokers. Where was it? The national part for brokers, only 51% passed. The affiliate brokers was 48% passed.
That's pretty consistent.
I know.
I mean, it's consistently running between about 55 or more percent of the people are flunking the national part. It's about 25, 28% flunk the state. I mean, you can extrapolate that. You figure every time that test is taken, 60% of the people in that room are flunking. I mean, and that's something we talked about when we had the education roundtable last year. I mean, and we asked, is it a real estate school problem or is it a student problem? And pretty much to a person, I mean, of course they probably would, but they felt that the student problem they got right now. Quality of students that they're getting coming in our business, because everybody makes the assumption it's so easy. And
in addition, they're taking online classes, so I think that.
Well,
That
if you
doesn't
take a
help
look,
things
the classroom classes and online classes, their pass-fail rate is pretty head-to-head.
Same.
They're pretty similar. Now, the pen and paper group, they're really way off. But they think it's the quality of people that are coming in our business right now.
We do have the updated 2019 PSI school report is now on the website. So that has each school's percentage for all of last year.
A couple of years ago, I was on the committee we met all day long with PSI, and we went over every question that was on the exams. And there were some questions that weren't even applicable to the state of Tennessee. So I think that kind of thing needs to reoccur. I don't know how often it needs to, but I was pretty shocked about how many questions were incorrect on those exams. I just want us to be as fair to the public as we can.
You mean incorrect in that they don't apply to our state?
Right.
Yeah, I can reach out to them. I think it's probably about time for another one of those.
Or even if they send us, and I know they have lots of different exams, and I almost said, let us see it, and then we can tell you that this shouldn't be on there. But we don't need to be handing out copies of the exam, so.
Yeah, no, I think that exam security is a big thing. And one other thing is that we do look at what other states offer the same national exam, and we use that when we look at reciprocity. So.
And the leadership at PSI and the management has changed also, so just something to think about.
Bobby?
We were talking about the people that maybe get their license revoked because of E&O insurance. I know that whenever somebody gets their license revoked because they don't pay child support,
They're on there, yeah.
they're on that report. It didn't say, it says revoked due to
Child support, it's suspended, yeah.
It gave the rule number. Or
Yes.
something like that. It didn't say they didn't pay child support, but it gave the rule number. You have to look it up and see what it was. But there was a bunch of them at one point, and
Yes, yeah.
they were on there. So
Yes, yeah.
I figured that would be the same.
Yeah, we can confirm that, I think.
And the other thing I was pointing out too, if you look on our report and you look at sanctions, I just did think it was interesting that we were running consistently double-digit sanctions up until about October. And then all of a sudden our number of sanctions has really dropped off. And so I'm just don't know what that is, whether it be change on the commissioners or change in our legal staff or something, but all of a sudden we're not having sanctions. So I don't know how to come up with that, but it's just interesting. So
Thank you, Bobby. Let's, while we're on this topic, we've got the May Tennessee Commission meeting, since you've got the floor right now.
Yes.
You've got it under commission discussion, but why don't we just talk
Okay.
about it right now? The deal is we don't have a place to meet yet, right?
We have not sort of figured out. It would technically we met in Memphis last year, so it could be time to go to Jackson, unless anybody else has another idea.
Have you reached out to anywhere to find out if we could come, or is this something that usually, like we used to have a Jackson member and Janet would take care of getting it there, or we had 3 Memphis members that would take care of getting it in Memphis or surrounding areas?
In my experience, it's been both. Sometimes the association will reach out to us and invite us before we even have to have the conversation, and then I can bring it to you. That has not happened yet. this year, so I
And
was
those
just
are the
bringing
two
it.
biggest, those are the two biggest towns? It doesn't have to be Jackson and Memphis, but that could accommodate mainly our AV requirements.
We have 2 or 3 requirements.
Yeah.
Has to be free.
Free, open to the public, and has to be video. You have to have video available. Those are the two main ones I think would have that kind of infrastructure, but I haven't, being honest, I haven't really explored it around. He's East Tennessee.
Well,
Oh, yeah, you are.
I think anywhere that has a board of mayor and alderman, or a city council, or county commission, that would probably be a free venue that has the same scenario of,
In the Collierville, that was very nice.
So maybe that's a question. We'll see Janet this afternoon, or her EO, and see. But we're 3 months away, basically, 3 meetings away.
Their executive officer will be at our next meeting. I saw him yesterday
Okay.
for their association in Jackson, so.
Okay.
Anyhow, but just put that in front of your mind right now, that we got to have, to satisfy the law, we have to find a place in West Tennessee to meet at least once this year. All right, any other comments or questions for the executive director?
excited when it comes to Kingsport.
Move up to the microphone.
But I'm just excited when it comes to Kingsport.
You can take care of all the arrangements, right?
Sure.
All right, good. That's what we'd like to hear.
Yeah, Dan's.
East Tennessee people are on top of it. I like it. All right, next up is the consent agenda. And Ms. Downey, you're first. Good to see you.
Good to see you. This doesn't stretch very well. Excuse me, I'm getting over a cold.
But
All right.
we don't need cold germs around here today.
Well, I'm not contagious.
You're going to have to get closer to the microphone regardless. Just no.
Think we'll be all right. Okay. Is everyone ready?
Ready.
Okay.
More than ready.
All right, so the consent agenda I'll start with the consent agenda for February 4th, 2020. Number 1 is 2019-069411. Number 2, 2019-070401. Number 3, 2019-070471. Number 4, 2019-070441. Number 5, 2019-070681. Number 6, 2019-070901. Number 7, 2019-070951. Number 8, 2019-071181. Number 9, 2019-071601. Number 10, 2019-072811. Number 11 is 2019-072621. Number 12, 2019-073791. 13, 2019-073841. 14, 2019-073621. 15, 2019-074531. 16, 2019-074441. 17, 2019-075021. 18, 2019-074911. 19, 2019-075601. 20, 2019-076021. 21, 2019-075552. 22, 2019-076641. 23, 2019-076741. 24, 2019-078141. 25, 2019-077021. 26, 2019-077221. 27, 2019-077561. 28, 2019-077871. 29, 2019-078161. 30, 2019-078131. 31, 2019-078491. 32, 2019-078401. 33, 2019-078361. 34, 2019-078701. 35, 2019-080201. 36, 2019-081861. 37, 2019-082711. 38, 2019-083191, 39, 2019-083821. And that concludes my portion of the consent agenda, and I recommend dismissal for each of those.
All right, the motion, the recommendation from legal is that each of complaints 1 through 39 be dismissed. Is there a motion to accept council's recommendation? I know
So
we're going to
moved.
pull some out, but let's get that motion on the floor.
So moved.
Mr. Diaz makes a
Second.
motion, seconded by Ms. Franks. Now, commissioners, are there particular cases you'd like to have removed? Ms. Franks?
I would like to pull number 5 and number 29.
Mr. Wood?
Anybody else?
Okay. 11, 28, 30, 33, 37.
All right, and I had number 4, just because I got confused. All right, so the motion on the floor is to dismiss cases 1 through 39 with the exception of cases 4, 5, 11, 28, 29, 30, 33, and 37. And 39,
29.
29.
Did she say 29?
Yeah.
I'm sorry, Marcia. Oh, I do
Yeah,
have it right in front of me.
29,
My fault. Thank you, Joe. All right, everybody understand the motion? Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Let's go to number 4 first. Okay, so you don't have to, let me tell you.
Okay.
So I'm just confused about who the players are. The complainant is a licensed principal broker. The respondent is a Tennessee resident. The complainant alleges that respondent is their landlord. Is that correct, or is the respondent?
The complainant is a Tennessee resident, sorry about that. And the respondent is the principal broker. So it should be reversed.
So like at the start of the second paragraph, the sentence says, respondent filed a response stating that they provided respondent with information regarding the court proceedings.
Complainant, it should say respondent filed a response stating that they provided complainant with the information regarding the court proceedings.
Next sentence says, respondent states the complainant was continuously late.
Right,
That
so
should
the
flip-
complainant is the tenant, the respondent is the landlord, who is also a principal broker. This complainant didn't pay their rent on time and informed the complainant about the court proceedings, and as a result, they were evicted and went through the proper channels. So there's not really anything we could do as far as discipline, because nothing was done that was wrong.
So as far as you can tell, the licensee didn't do anything wrong?
No.
Okay. I move to accept council's recommendation and dismiss number 4.
Second.
The motion was seconded by Ms. Franks. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 5, Marcia.
So number 5, it gets down to earnest money and when does it need to be returned. And the big question is reasonable interpretation, which is left up to interpretation, I suppose.
Right.
I don't know. I just think that there was so much, opposition to giving it back. I just think, as a principal broker myself, I would have interpleaded it where there'd be no question about it. because it didn't sound that clear to me. So I'm just thinking that maybe a letter of warning, just so that this person understands the severity, or what is the one that doesn't even go in their file other than letter of instruction, maybe? I'm just thinking something, because, I mean, this could lead to a big lawsuit for them too, so, I don't know, what do y'all think?
Well, I thought that was one of the options for the broker.
It is.
And so they chose that option. You know, it may not, it still probably wouldn't have been, doesn't like it was going to have been your choice, it wouldn't have been my choice either, but it was still a choice they had. And so I don't think we need to go telling them, you're making bad business decisions.
So here's my advice. Like Commissioner Woods said, that is their choice. The regulations allow them to do that. And if a person disagrees with that choice, we are getting out of the realm of regulation and into contract interpretation. And therefore, I would advise that you don't intervene in something like that. They have other remedies, such as going to Chancery Court or Circuit Court if they feel that they've been wronged in this situation, but I do not think it's something the commission wants to get entangled with, even sending a letter of instruction in something like this.
So it would take a Chancery Court to decide whether it was a reasonable interpretation.
Yes, we're getting into contract law, which is not what we want to be involved in.
Okay, then I'm move that we accept council's recommendation to dismiss.
Second.
Motion by Ms. Frank, second by Mr. Diaz. The council's recommendation be adopted and complaint number 5 be dismissed. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Bobby, number 11.
Okay, if I remember 11 right, agent had a buyer's rep agreement, and then the agent left the company that they were with, and the agent responded to saying they talked to the buyer and asked the buyer, do you want to go with me or do you want to stay with the broker? And the buyer says, I want to go with you. But they don't get that, but the buyer had a contract with the company. And so I don't think, I mean, when they're doing that, they're trying to get somebody to break a contract. I mean, wouldn't that be contractual interference? I mean,
So for the transaction you're talking about, there wasn't a contract yet.
not a contract. The
Buyer's
contract is a buyer rep agreement, and that is a contract.
I don't think that they had signed it. The complainant's clients, they had not yet signed the buyer representation agreement for that particular transaction. Well, let me read it.
But
and
the
make
complainant said they had one. So but that doesn't necessarily mean
But
they
it
had
hadn't
one.
been signed yet. Neither party had signed it. They were about to make a decision about choosing their representative or their licensee, and they didn't yet sign the exclusive buyer representation agreement. So when the respondent was leaving, the complainant was leaving that firm because it had not yet been signed. They asked if that person, the client, wanted to come with them instead of staying with the firm. But let me look at this real quick and just make sure I'm not.
Because I'm not
mistaken.
seeing anywhere where it said that it wasn't signed. The complainant says it was signed, but I didn't see the respondent.
Give me 1 second.
Okay.
The second paragraph about the fifth line down, it says the agreement.
Yeah,
Okay,
so it
thank you.
hadn't been signed yet. So that's why I recommended dismissal, because I do think it would have been an issue if they had signed the
Okay.
contract.
Good with that.
Yeah.
Okay. I move to accept council's recommendation to dismiss.
Second.
All right, Mr. Wood's motion, seconded by Mr. Diaz, is to dismiss case number 11 per council's recommendation. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Bobby, 28.
I kind of.
Is this one that they had the equity interest or something?
So this was a little bit of a strange one. This respondent he was entering into an agreement to obtain interest in the property. The seller had, and I've got the documents, but the seller had given them their agreement to basically sign over the rights to the property to the respondent. Well, before the respondent filed the deed and paperwork to put on notice that he was now the official owner of the property, there was an individual who wanted to purchase the property based on the respondent uploading something on some website about his property and how it would be a good investment property for someone else if they wanted to purchase it. So when the complainant saw this, they contacted the respondent, and the respondent basically paid $2,500 for the property, but then charged the complainant charged the complainant a down payment of $2,500 and then an additional $12,000 on a 3-year note, or they could just pay them a full purchase amount. So the complainant took this respondent up on the offer, and they basically did a transaction for the complainant to purchase the property. Well, when the complainant got the property was not what they thought it would be, and as a result, they got really upset about the transaction and thought it wasn't really fair. Now, I would agree with the complainant if the respondent wasn't the owner of the property and was representing a seller in the transaction, but because the respondent was the owner of the property, they weren't violating any rules by trying to upsell their property. It's a little bit, I guess, shady in terms of how the transaction, or how they charged, the amount they charged for the property, but they didn't do anything wrong because they did own it, and they did provide me with the paperwork where the property was signed over to them, and I mean, all the documentation shows that the transaction wasn't illegal, and he didn't do anything in violation of the rules and statutes.
But I don't think they owned it. They just had a contract to buy it. But they didn't really own it. They never bought it.
I'm going to pull up the file because I had the same thought.
Because we had this, Kelsey Bridges was the one that talked many weeks on this.
Oh, okay.
And we came, I thought we came to a conclusion that
This was
an
one of
equity
hers.
interest is not, you're not an owner.
Well, let's talk
I think we came to opposite interest.
Because
Oh, really?
Opposite thing, that equitable interest gives you the right.
I don't think that that's the proper way to look at it, because you have an equity interest, you're not the owner.
Not the owner, you're not on the deed.
And we argued that point with Ms. Bridges ad nauseum.
Well, you know how it is, if you have 12 attorneys, you can get 12 different opinions.
Well, but I know, but it's our opinion that counts
I know.
here. But I don't think this guy, as Bobby says, ever owned this property. I think he just had a contract on it, and he sold his contract, basically.
He wholesaled it.
That's what I think happened.
Because if the contract said or assigns, then that's perfectly fine.
It says the contract, hold on, I have the contract here, so I'll just look at it.
If you don't own it and use the as a son, are you still operating under an owner or a realtor? Which is the argument here. Were they operating as a professional realtor, or were they operating as an individual owner that?
Well, and I think my question is, even if you are the owner, if you're a licensee, aren't you still subject to the statutes?
Yes.
I mean, in Tennessee, you can assign your property to someone else via contract, and then they can do what they will with that assignment. That doesn't mean that they're in violation of the rules because they only have an assignment of the rights to the land via a contract. So essentially, because they have that assignment, they would be considered the proper party to sell that assignment, to do, whatever they want to do with it. So
I'm sorry, Ms. Downey, from your reading of the contract, this agent sold his assigning interest and not the property.
right.
So the contract says or assigns.
The contract says, which contract are you talking about? The original
The
one?
purchase and sale agreement.
Okay, let me pull that up.
I guess the agreement between the owner and the agent that says, I assign your interest to you.
Let me look at,
Is it the Tennessee Realtors form?
it is.
Is
Then
the-
it allows you to assign it, yeah.
So just so we're clear, the interpretation that we said is if you own the option, you can sell it. You own the option, not the property, until you exercise the option.
But the essential issue we need to focus on is whether this person owned the rights to do that. And if they own the rights to do that, then they're not doing anything wrong in terms of a real estate transaction. They're not representing the seller. They're representing themselves and their interest in the property. So as long as they're not representing the seller and trying to make a transaction on behalf of someone else, I don't think the rules would allow for us to discipline them for this.
Does your file indicate whether or not the agent property at all?
I'm sorry, repeat that for me?
I'm just wondering if the agent misrepresented the condition of the property to the complainant.
I don't see anything that would lead me to believe that they misrepresented anything. They waived the inspection. I mean, it's nothing in here that's showing that they made any affirmative statements about the property in the forms.
It's confusing because they say, the respondent says they're not acting as, weren't acting as a realtor, a real estate agent in this, but then they also talk about collecting $6,000 commission.
That's what the complainant alleged. The respondent was basically just selling his or their land for $6,000 more and received a profit. And they only paid $2,500 for
Well, there's nothing wrong with that. That sounds like
Yeah.
a good deal to me.
Right, so that it wasn't a commission to the complainant. They looked at it as a commission.
But you can't take one part of it and be acting as a realtor and another part of it and you're not a realtor either, though.
Licensee.
A licensee, sorry.
We don't, this sounds,
I
doesn't
know.
sound like a realtor to
I
me.
know. I'm a
All right, Mr. Wood.
Well, I would say this, because they're saying that the Trek statutes and rules, that they were exempt because they own the property, but technically, that statement's not true, but they own
The rights.
that right to do that. So
Right.
I'm going to say I move to accept council's recommendation to dismiss.
Second.
All right, Mr. Wood makes a motion to accept council's recommendation and dismiss complaint number 28. Mr. Diaz seconds. Before we vote, just out of curiosity, Kristen, you may not be able to answer this. This guy had or lady had a previous consent order for $1,000 for unlicensed activity in 2017, but the data above that looks to me like he was or she was licensed during that period. Is that,
I would have to,
it's not pertinent.
I can look it up. It may have been that their license was expired.
It won't change my vote.
I'm assuming their license was expired and they were working at
They
that.
got it back and it backdated to when the, okay. Let's vote. Those in favor of the motion to dismiss, please vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 29, Marcia.
That's me. Okay, so this is the short-term rental one, right?
Yep.
right.
Okay, so, has there been an opinion by the Attorney General or anyone that says that we have nothing to do, that this commission has nothing to do with short-term rentals?
Notification.
And then why are they not, aren't they a vacation lodging service if they're doing short-term rentals?
That's 14 days.
No,
Is it 14 days that you have to, or more?
I thought it was 14 days or less was vacation lodging.
Oh,
No, my fault.
Because the recommendation is this is a short-term rental service which does not fall within the commission's jurisdiction. But I thought that we've had a couple of these things come before us, and obviously I'm not clear on, what is our standing? Do we hear these or not?
Not a. So, it's no more than 14 days for a vacation lodging service.
Okay, so how many days are they renting out these units? These short-term rentals?
I mean, I'm not 100% sure. It varies on their website. I'm not sure. This particular complainant didn't provide any information as to how long the individuals would be there, but it seems to me, just based on looking at their website, it's probably like a weekend type deal, maybe 3-4 days.
But you can't be sure about that.
There's no way I would be able to know that for sure.
Bobby?
Okay, so, but the vacation lodging service, we have that firm license that keeps you from having to get a real estate license, right? Because if you're renting for less than 14 days, you can get the vacation lodging. If you're basically renting, say, a month or more at a time, then you have to have a real estate license. So if
They're
you're
doing one or the
you got to
other
do
of
one or
these.
the other. And so by the fact that they're unlicensed tells me they don't have a real estate license. So if they're doing this, they need to have a vacation lodging license.
Sounds like an Airbnb almost, like a bunch of
It is.
Airbnb properties.
But there's lots of flavors of this now. It's not just the big national companies anymore. I mean, there's people in Franklin that do it just for Franklin places,
So if they're owning if the respondent owns their particular properties and they're choosing to rent them out, I don't believe that would be qualified as a vacation lodging service.
Are they an LLC?
Let me look and confirm. Hold on. They gave me something.
They do say they have a registered agent.
Yeah, they have a registered agent. I believe they,
Have a registered agent?
with the state of Tennessee.
Yeah.
Not
That doesn't necessarily mean LLC though, does it?
not
No,
necessarily.
not necessarily.
Yeah. And I'm confused about the line, respondent filed a response stating the complainant fails to state a claim upon which relied can be granted.
So they are not, they don't really, they don't seem to work with TRIC often, and didn't really understand that this is more of a regulatory commission and not like you're filing a complaint against somebody in circuit or chancery court. Because if you file a complaint in circuit or chancery and you don't state a claim for relief, then it can be dismissed. But this is a regulatory commission.
But that's the respondent saying that.
Yeah,
Who owns the 55 properties?
that was their attorney filed that.
Well, to me, they got to fall in one place or the other,
Not a-
and they're neither,
Unless they're exempt.
They're,
unless they're exempt. So what's their exemption?
They're
They're
incorporated.
they're,
corporation.
yeah,
It's corporate, it's
It's a
an incorporation, okay?
So they can,
Okay.
they can do their own.
That's what we
Yeah.
needed to know then.
it's not an LLC.
Okay.
I just had to look it up with the Secretary of State.
Okay.
All right, Ms. Franks, your motion.
Move to dismiss.
Ms. Franks moves to dismiss case number 29, and Mr. Diaz seconds. Further discussion? Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 30, Bobby.
My question had to do with the earnest money and what ended up happening to it. Maybe I just didn't read what happened to it.
Got it real. Well, I never got a conclusion as to what ended up happening with the money. I know that they were fighting about it. There might have been some sort of legal action that was taken in terms of state court, but I never got a confirmation as to whether the money was ever sent back or not. But because it is an earnest money issue and they do have a dispute about it, I don't think that we can do anything to punish them because
Being litigated.
they have reasons as to why they didn't give it back originally that seem to be valid reasons. So I think if they do have issues with getting their earnest money back, probably Chancery or Circuit would be a better venue for them to fight over that.
Well, and an affiliate broker cannot return earnest money in the first place.
That's true, too.
But I thought that our 21-day rule is to kind of move things along, because people could say, well, we have a disagreement over it, we want to let it sit in our account for infinity. And the 21-day rule is to basically say, you make a decision one way or another, or interplead it.
Well,
And-
either party could interplead it.
No, I think only
No, you
the
have to be the
people.
holder of the money.
Yeah.
Well, I don't know what else we could do in terms of that.
Well, if they don't follow our rules and that interpleading it after the 21 days, then we can,
But if they, so for me, when I read this one, I think they did have a compelling reason as to why they hadn't distributed the money back to this complainant. And because of that, I don't think that that's something that we should get in the middle of when they're fighting over the earnest money.
so you're thinking the compelling reason is they're fighting over it, and that's why,
Well, no, the the transaction failed as a result of something that the.
They had a higher offer. They got another offer, and they had a higher offer.
okay?
Well, I don't think that's necessarily
You wrote it in your
why.
last paragraph.
That's what the complaint alleges.
Yeah, that's not necessarily what occurred. It seems like there were just a lot of different delays involved with the appraisal and the disagreements.
But doing nothing with the money is not one of the choices.
What confuses me is the narrative says the respondent's client would not release earnest money. So was the client holding it, or?
No, the client wasn't holding it. That's just what was alleged.
If they did nothing with the money.
Yeah,
So the money's still in their account? That's not right. They had 21 days to interplead it or do one of these
Make a decision.
things. They didn't even do it upon a reasonable interpretation of the contract, right?
They just did nothing.
Well, I do not know what the status of the money is at this point. I don't know if it was returned back or what happened. I don't have that information in my possession. So they could have returned it. I didn't get any confirmation about that.
A broker, if a contract expires and it's terminated, I mean, a reasonable,
You give it money back if it expires.
that's what I think.
Yeah.
If they're just holding it out of spite, or because their client says not to give it back, that's not a reasonable interpretation of the contract.
Can we keep this open, but then open a complaint against the broker? Because that's who's holding the money, right?
And here's the thing that I do not understand about the state of Tennessee. Most every other state has investigators, and they are real estate specific investigators. I feel like the investigation is being left up to our attorneys, who are not investigators. They're not trained investigators. So, I mean, I have a real problem with this that, I mean, otherwise, we could have had an investigator come in and I could ask him, well, why didn't you find out where the money went? And if you're not a realtor and you're an attorney, you don't know to do that either. So there's a real gap in all of our meetings where we really don't have qualified investigations going on. And I don't know what to do about that.
I'll notice there were several cases investigated this
Right,
month.
right.
I don't know who the people are, as you say, and it may be specific to East, Middle, or West Tennessee.
And they may be investigating funeral homes too, you know?
Well, they probably are.
Yeah. But there's no one we could directly say, you know, or get their opinion to come here and tell us, this is what I investigated and this is what I found. And I mean, all states do this. And we have, at Arello, there's a whole group of investigators and they all come together and they learn about how to do real estate investigations. And we have no one from this state to even send to those things because we don't even know who the investigators are.
Well, I'll let Caitlin respond in just a minute.
Okay.
I want to go back to Bobby for a second. So you're in the middle of a thought.
My thought is maybe the person that we really need to be talking to is whoever's holding the earnest money, the real estate broker, or the principal broker. And I'm thinking, let's hold this open, but let's open a complaint against the real estate broker, and then we'll get to the bottom of the earnest money.
So because an affiliate broker can't hold the earnest money, I don't think we should keep this complaint open against the affiliate broker, but we can open a complaint against the principal broker and do more to determine what actually happened with the earnest money.
Or, before we scare the heck out of this principal broker, I mean, a phone call, emails could have been done to this broker to find out where's the money. I mean, do we want to have something in their file where they've had, charges brought against them? Is it something that we can close on this affiliate and leave it, I'm not saying filing charges, but I don't know what the remedy is to what I'm trying to get to, where we can just have a courtesy to this person to find out where's the artist money?
Well, I don't think that if we open a complaint when it's decided upon.
I guess my question, since affiliate brokers cannot hold earnest money, what would be the violation that would?
Oh, we're clear on the affiliate broker here.
Right,
We're
so
talking about
I
the-
guess I'm with keeping the complaint open. I don't see the harm in opening a complaint against the principal broker, because if it's open and we find out that they disperse the money, then most likely the recommendation is going to be dismissal. And so they're the person I think we need to get the answers from in this particular instance.
Okay, Mr. Wood, would you agree that since,
I'm okay with that.
okay, would you make a motion then?
I'll make a motion, we accept council's recommendation to dismiss, and then do I need to do a separate
Let's
one?
vote
do
on
this
that
first,
first.
okay.
Is there a second to that motion?
Second.
All right, Mr. Diaz seconds that motion. Discussion. This motion passes. The complaint against the affiliate broker will be dismissed. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Mr. Wood.
I'll make a motion that the principal broker who's holding the earnest money in case number 30, that we open a complaint against them about not handling the earnest money properly.
Second to that motion.
Second.
Second by Ms. Franks. So this motion, if it passes, will open an administrative complaint against the principal broker referenced in case number 30. Those in favor of that motion, vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 33, Bobby.
Let's see. If I'm looking to, I made myself a note that the licensee didn't respond to this.
They ended up responding, but it didn't, they didn't respond within the 10-day time period.
Okay, okay. And then,
But they're unlicensed.
Well, they own the properties that they were renting out.
But they're unlicensed.
But it's not, that's the problem. There's a sentence in there that says they are a real estate licensee.
I'm sorry. They filed it against the company, not against the licensee. So this person is a licensed affiliate broker, but he owns several different properties through his corporation and rents them out. But it's under his corporation's name, not under his name or the respondent's name. And it's not an LLC.
And you have that proof?
Yeah, they sent it to me.
except I then had a question, is there a broker But it would be the broker or the spot, but the issue is the complaint was filed against the company that's not a licensee.
It doesn't need to be
Okay.
one, so.
Okay, I'll move to accept council's recommendation to dismiss.
Second.
Mr. Diaz seconds Mr. Wood's motion to dismiss. Those in favor of that motion vote aye.
Aye.
Those
Aye.
opposed, no. The motion passes unanimously. 37. Bobby?
This was interesting. In the third paragraph, it talks about the affiliate broker was instructed to get the seller's signature as required by the state to release the funds. And I don't think that was true. And I think this is another situation where they're holding the earnest money. Am I right on that?
Let me-
Last line says why the funds could not be released within the 21-day time frame.
Oh, yeah, they couldn't find the owner of the property. So they were thinking they were doing the right thing by doing their due diligence in trying to contact this seller who had all these liens and ended up having a foreclosure on their home. So they did have a good reason as to why they were holding on to it. But it did kind of go beyond the 21-day time period. But I do think that there was a good reason as to why they had not released
What's the
it.
reason?
They couldn't find the seller who ended up foreclosing.
But I think that's a great reason to give it back, not to hold it.
Once again, though, technically, this is against an affiliate broker, right? Not the principal
Well,
broker.
it says real estate broker, doesn't it?
I know, but
It's an affiliate.
if you go to the second little
Well,
sentence.
no. It's
Type of
the-
license
it's
is real
against the
estate broker.
principal broker, sorry.
Respondent
Okay,
is a
my
licensed
fault.
principal broker.
Got it. Sorry, Bobby. Go ahead.
And my thinking is, I mean, this one, we may have the right person, and but this person just doesn't understand the law. I mean, they don't understand the law. I mean, because they had all kinds of opportunities on how to disperse this money, but they just didn't.
Do you guys think sending a letter of instruction might be beneficial?
But where's the money?
They returned it to the buyers. It just took longer than the 21-day time period.
I would make the motion. I mean, I don't think they've got it. I mean, these people, this broker doesn't understand the rule at all, and they don't read their own contracts either. So I
Take the broker class.
Well, I think we got two issues. One, I think there needs to be a $1,000 civil penalty for not abiding by our earnest money rule. And then second, they need to take a what was the broker?
It's the broker, it's the principal broker core class.
The principal broker court class within 180 days, and they're not to get CE credit for that.
So just for my own understanding with respect to how you guys operate in a regular course of business, when you have a seller and you have the earnest money and you're not able to obtain their signature to release it, what typically happens? Is this when you all would expect to do the interpleader if it's going to go beyond the 21 days, or just release it because you can't find the seller? Explain that to me.
I've been a principal broker for 30 years, and I can tell you this has never come up, because usually a person getting money back, they will make sure you know where they are. So had this had happened to me, in 21 days I couldn't find them, I would have taken it over to the courthouse and filed an interpleader.
Where I probably would have done, I would have probably, if the seller is running off and they're letting the house go away anyway, they don't have an interest in this, I'm going to go ahead and I'm going to make a reasonable interpretation of the contract, and I'm going to send it back to the buyers.
Okay.
I mean, because, if the seller had an interest, they would respond to you, or you'd have a way to get a hold of them.
I think, like what Vice Chairman Frank said, this isn't something that really comes up. So I think when the respondent was presented with this obstacle, maybe it wasn't necessarily that they didn't understand the rules more than it was just a situation that they had never been involved in before. And I think there was an attempt to comply with the rules. So with that being, and they don't have a history of discipline. So with that being said, I don't think that assessing a $1,000 civil penalty is something that might be necessary in this instance. I think maybe considering if you just want to do a civil penalty, maybe reducing that a bit and sending, just putting in the consent order, the rules and making sure they know them.
All right, Ms. Downey, let's hold your opinion for a second. Let's see if I can get a second to Mr. Wood's
Second.
motion. Okay, so it's properly on the floor now. Now we've got advice from council, discussion, other members of commission.
Well, he didn't finish.
Well, and I was going to say,
Class.
the Tennessee Realtors
Class, he did say
have a hotline where brokers or any agent can call, and if they got any kind of legal question, they would have been glad to give them an answer for free. And they chose not to go that
So would
direction.
track,
either.
so would
Yeah.
track.
We don't give legal
No.
advice.
Not legal advice, but you could tell them they have 21 days. And you could tell them where to go in the statute to look to see what their choices are.
I would suggest a license, see if you're a realtor, get it from the Tennessee Realtors, because they'll give you a
Well,
specific answer.
Are you sure that they're a realtor?
Nope.
The law is the law.
Right.
Agree, but they wouldn't be able to use the
Is this a rule?
hotline.
Or read the book.
Yeah. All right, so the motion on the floor, made by Mr. Wood, if passed, would offer a civil penalty of $1,000 to this principal broker and also require that he take the principal broker's core class within 6 months with no possibility of getting continuing education credit for that course. That's what's in front of us. Are you ready to vote?
Yes.
All right. Ms. Frank says we're ready to vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, do you all need a quick break? I can't lose a member at a time, so let's take about a 5-minute break and we'll get started with Ms. Matlock.
Are you?
All right, ladies and gentlemen. Anna, before we get started, I need a commitment from Caitlin. Okay, Caitlin, listen closely. I need your commitment to get members of this commission out of some cybersecurity course that we're supposed to take between now and June 30th. So will you get that done?
I have already asked about that.
Well, no, I didn't ask if you'd asked about it. Would you take care of that, please?
I will try.
Is that email we got?
Yeah, and you got until June 30th, which is, I mean, I can forget that many times between now and then.
You didn't highlight it in red in your emails?
No, of course, I didn't. It just doesn't apply to me. It's somebody likes to send out blanket emails to everybody that's got an employee number, I guess. We don't qualify as employees, clearly, so I assume it doesn't apply to us. I hope it doesn't apply to us.
I have a good feeling that it doesn't. I believe that you got out of it last year.
This is our only cybersecurity, and it was taken care of by
I can't even
them
tell you
that are
that.
going to have to
Yeah.
take the class.
Yep. All right, let's get back to the regular business. Ms. Matlock, courses, cases 40 through 75.
We're still on.
Number 40, 2019 080181, 41, 2019 080571, 42, 2019 080931, 43, 2019 081061, 44, 2019 081741, 45, 2019 081161, 46, 2019 081191, 47, 2019 081761, 48, 2019 082121, 49, 2019 083431, 50, 2019 084011, 51, 2019 084391, 52, 2019 084221, 53, 2019 083691, 54, 2019 083411, 55, 2019 083321, 56, 2019 083361, 57, 2019 083391, 58, 2019 083441, 59, 2019 083931, 60, 2019 084121, 61, 2019 085741, 62, 2019 092241, 63, 2019 092231, 64, 2019 091101, 65, 2019 093701, 66, 2019 093801, 67, 2019 099781, 68, 2020001341, 69, 2019 084041, 70, 2019 085891, 71, 2019 086651, 72, 2019 091001, 73, 2019 091231, 74, 2019 091361, 75, 2020 01811.
Recommendation.
And my recommendation for those complaints is dismissal.
All right, is there a motion to accept council's recommendation and dismiss cases 40 through 75?
So moved.
Motion by Mr. Diaz, seconded by Ms. Wood. Now, commissioners, if you have cases you'd like to pull out of that motion, Mr. Wood?
I do not.
Okay, Ms. Franks?
I do not.
Anyone? I have a question about 45 and 46. It'll just take a second.
Hopefully.
With that said, are you ready to vote? Let's vote. Those in favor of the motion to dismiss cases 40 through 75, with the exception of case 45 and 46, please vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, on number 45, I get confused on the shortest cases. But the last sentence in the second paragraph, I underlined, respondent provided two statements from two different companies stating respondent has a valid lease and is allowed to sublease the properties. Is that what was going on here, or did he just buy the property subject to the existing lease?
So the respondent is not the owner of the property. They are, so on this particular lease, the two respondents in 45 and 46 are listed as agents of the landlord. So they weren't acting, they're not, I don't believe they're the proper party to this transaction. So the people that actually own the property are the ones that submitted the statement saying they have the right to sublease that property.
But I would think the tenant would have the right to sublease, if indeed there is a sublease.
That's what a sublease is.
That's why I got confused.
Okay, so hold on 1 second. I'm kidding. The complainant is the tenant, and they're alleging that the respondent is the new owner of the home that they were renting, and the respondent is basically a landlord. That's what's happening in this particular instance,
Not the owner.
but not the owner.
But my confusion is that even the owner / landlord or agent for the owner / landlord doesn't have the right to sublease. And the tenant would have the right to sublease to another party, perhaps, if this lease allowed that. But were they trying to kick the tenant out, I guess is what I'm trying to get.
No, they weren't. they weren't trying to remove them from the property or anything. They were just telling them that we are the new individuals that are in charge of this property, and that you should be paying us and not the former individuals.
So the complainant's basis for filing a complaint was that a new owner?
Yes.
That's it?
Like, to me, like the way they handled it, like they came in unannounced, and is that,
Right, I don't have any evidence to suggest that they came in unannounced. They didn't state that they came in unannounced. That's just what the complainant says. All the complainant provided was that narrative and a copy of the lease that respondents were on. It seems like they were upset that the respondents are the new owners, and I guess it wasn't communicated to them, but I don't know for sure if they actually came into the property or not.
stated, it says they came into their home in line 2.
In line 2, that's what the complainant says.
So this, I never would have asked this question at all,
Okay.
I don't think, if in the second paragraph, the last sentence, it read, instead of respondent, it had complainant in each place. So complainant provided 2 statements from 2 different companies stating complainant has a valid lease and is allowed to sublease the properties. Because that's who has the right to sublease properties, I think. I mean, that's how I understand this. Okay, I'm done. That's all I have.
So I'm wondering too, on these complaints, where the first line is always, the complainant is a Tennessee resident, respondent is an unlicensed individual. If the next line could tell us, this is their complaint, they complained whatever. Because it has to be something within our jurisdiction, really, or it goes on the consent agenda, right?
This is on the consent.
That's what I'm saying.
So even if it's not in our jurisdiction, so I don't believe this complaint, sometimes when there's a question of who is, if this falls into our jurisdiction, that question will come to me, and I'll say, no, we don't have jurisdiction over that. Yes, we do. And if this particular instance, if this had come across me, I would say, no, we don't have jurisdiction over it, because this seems like more of a landlord-tenant issue than an actual real estate transaction issue. And so that's kind of what happened here. But we can do that. I guess
So are you saying sometimes they don't come to you for an interpretation?
Right, so if sometimes, like, just based upon, okay, so if it's against an unlicensed individual, sometimes it'll just be referred to the real estate commission, because when you submit a complaint, you determined, I would like to file it with the real estate commission. And so they'll put the individual's name in there, and they'll put in the information, and based off of that information, if it looks like it falls under the jurisdiction of the real estate commission, sometimes it'll be referred to us. Sometimes the individuals that are reviewing the complaint are confused and ask whether it falls under our jurisdiction, but sometimes I do not get those questions. I don't get them all the time, because if I did, for how many unlicensed complaints, I would be doing them like every day.
Who does do them?
So we have our centralized complaints division processes the complaints, and so if they're done online and everything is filled out, so this person's name and information for both of them was filled out, so it was sent to them by the
No,
centralized.
I'm talking about when it comes into our office here. When it comes to the complaint department, you said that you look at some of them, but some of them you don't.
Correct.
So who's looking at the ones you don't and making those determinations?
So if no one makes the determination, it's just referred to the commission. And then sometimes we make the determination that it doesn't fall under our jurisdiction.
All right. Chair will entertain a motion to dismiss 45 and 46.
So moved.
Mr. Diaz makes a motion to dismiss. Mr. Wood seconds. Let's vote. If you're in favor of dismissing cases 45 and 46, please vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Okay, we're on to the February legal report. Ms. Downey?
Okay, number 1 is 2019-070921. The complainant is an out-of-state resident. Respondent is a real estate licensee. Complainant alleges that respondent sent them an email stating, "The day you made the offer, I did in fact tell you I would be relinquishing my rights as a seller's agent and the buyer's agent." However, complainant alleges that respondent did not state this. Complainant further alleges that the purchase sale agreement did not indicate whether the seller accepted, countered, or rejected the offer. Finally, complainant alleges that respondent included incorrect information in the MLS listing and stated that they cannot control what Zillow puts on their website. Complainant alleges that the listing indicated that there was a 12-car detached garage, a fireplace, and central heating. Respondent filed a response stating that they verbally told complainant that they would relinquish their rights as the buyer and seller's agent the day the complainant made an offer, and also sent complainant an email stating this. Respondent attached a confirmation of agency form in which respondent is listed as the facilitator. Respondent sent an email to the complainant stating that the seller accepted the complainant's offer. Respondent attached a copy of the purchase sale agreement and the email sent to the complainant, which includes the buyer and seller's signatures. However, none of the boxes are checked to indicate whether the seller accepts, counters, or rejects the complainant's offer. With respect to the MLS listing, respondent states that at the time the listing was posted, it was difficult to communicate with Zillow and they did not cooperate with updating listings. Respondent attached a copy of the MLS listing. The listing indicates that there is a 4-car carport with detached 8-car gravel parking spaces, an unspecified number of fireplaces, and electric central heating. I recommended a letter of warning regarding the updated and current MLS listings because when I looked at the listing, I could see how it would be kind of a misrepresentation of what the property actually had, and as a result, I think this respondent should be aware that they're required to keep their MLS listings updated and current.
Was the problem with the MLS listing or with Zillow?
Well, from the information I got, the respondent is saying it was with Zillow, but the MLS listing, it just doesn't have the same information that the respondent and complainant both agree.
Does it show 12-car garage?
It does say 12-car garage, but it doesn't.
In the listing or on the MLS?
On the MLS?
Let me look at it and double check, but I believe it did show 12-car.
I would think that'd be a red flag to anyone.
Your last sentence says the listing indicates there's a 4-car garage with detached.
Let me go back and look, because
Okay.
I might be mistaken about that.
I can see how Zillow's computer might have made that misinterpretation.
Okay, sorry, I'm mistaken. It says parking
Basis.
for detached, and then it says 8 gravel.
Parking pad, 8 gravel.
I could take an 8-car gravel parking lot and make it 9.
In addition, aside from the parking, it did indicate that there was central heating, and that wasn't the case. The MLS listing says that, but that wasn't true.
I see 2 problems here.
Okay.
First, the contract wasn't accepted, countered, or rejected.
Yeah,
That's
that was the
problem
other
number
thing.
1.
Yeah.
And then problem number 2 is that they were saying there was discrepancies in the MLS, which now you're telling me that there weren't.
No, so.
So
there
I'm off of
is-
the MLS discussion and back to the accepted, countered, or rejected.
So the MLS listing did still have issues. It did show, I guess it could have been interpreted that, it didn't say 12-car garage, but it did say that they had central heating, and they didn't have it in on the property. And the real other issue, I think, is not specifying the acceptance, declining, or part of the offer.
So that's where I've landed, is on that.
Okay.
That wasn't properly done, and so that goes to skill and care, in my opinion.
Okay.
What does everybody else think?
Did the complainant buy this property?
Did the complainant buy it?
Yeah. Did it close?
I don't think that gave me any, well, hold on, let me see. That gave me the documents.
Like a HUD statement?
Yeah, I'll check and see. I did attach the purchase sale agreement, which is on a TAR form. I
The
don't,
one,
But not the HUD
I
closing
don't
form.
see a HUD closing form, though.
And do you have a form that shows that this person was a facilitator?
Yes, I do have on here that they were a facilitator.
So they're not representing either party?
They,
That's what that means.
no, they are listed as a facilitator on here.
Is there like a walkthrough inspection included in those documents?
So, I'm not walk through.
Like a property condition disclosure form?
Oh, there's a Tennessee residential property disclosure form in here.
Talk about the heating system or number of fireplaces or,
Back to it.
Or any exemption from it?
Thing about that.
so we don't really know if there was even a contract because it was never checked, accepted, rejected, countered.
They didn't check
Right.
either of those, but their defense is that they emailed that it was accepted, but it's not indicated on the form.
So they like dot looped it, or they sent an email,
No,
I
they
accept?
sent an email saying, they accept.
All right, Ms. Franks, you're on target. What do you want to do?
I want to assess a penalty of $500 for skill and care, lack of skill and care, and a 4-hour contracts class.
Second. All right, the motion on the floor made by Ms. Franks, seconded by Mr. Wood. If passed,
I have one question.
let me state the motion just for one quick second before I forget it. If passed, would offer this licensee a $500 civil penalty and also require that the licensee take a 4-hour contracts course within 180 days. It will not apply toward continuing education requirements. Mr. Begley, sorry.
Was there any counter offers in there?
No, I didn't see any.
And was the page that you're looking at, that there was no acceptance or counter, was it binded below that?
Was it binding? Let me
Right
go.
below that?
Right below it.
Hold
Is
on.
it a
If they
TR
didn't
form?
sign, if they don't have a sign or anything, they're not gonna have a binding date on
Let's
it.
see that.
I'll find that page. It's a lot of documents here.
It would be underneath the signatures
Okay.
on the 10th, 11th page of the purchase and sale agreement.
What was the
Right.
question again?
I know,
You see where those boxes are that they didn't accept, counter, or reject?
Uh-huh.
Below that, there's going to be a line that says binded, like
Binding
someone
date.
signed it on a date and time.
Or acknowledgement of receipt.
And there's supposed to be a signature there. Yeah, there's a signature here. But they sent me a second purchase sale agreement that did have it correct. So I think I'm looking at the
And what correct?
They ended up checking the box after it was brought to their attention that there was no box checked. So that was the second one. So let me look at the first
And
one.
what did they check?
They checked accept on that one, but the first one they did not after.
Okay, so it still goes to my point of skill and care.
Yeah, it still was a problem. It had to be brought to their attention.
Commissioners, are you ready to vote? Okay, the motion, once again, is to offer the licensee a $500 civil penalty and require a 4-hour contracts course to be completed within 180 days. Those in favor of that motion, vote aye. Aye. Those opposed, no. That motion passes unanimously. Number 2, Ms. Downey.
Complainant is a Tennessee resident. Respondent is a real estate licensee. Complainant alleges that they listed their property at $329,000. They received and agreed to an offer of $315,000 with complainant seller paying $2,500 of buyer's closing costs. The closing was scheduled and the home was appraised. The appraisal came in at $291,000. Complainant attempted to negotiate and asked their agent to submit a new offer for the appraised value with no payment toward closing costs, no home warranty insurance plan, and no appliances included. Complainant's agent submitted the offer, but before receiving the response, the complainant changed their mind and advised that they wanted to rescind the offer. Complainant did not hear back, but the original contract expired on August 15, 2019. On August 16, 2019, respondent sent an amendment to the purchase and sale agreement that was signed by the buyer with an amended sales price of $291,000. Respondent also sent an RF 656 notification stating that the buyer was terminating the sales agreement and demanding the return of the earnest money, stating that the complainant verbally agreed to sell the house for the appraised value.
Well, let me ask one question. Isn't this whole thing about the person's unlicensed?
Oh, yeah, we can just skip to that part.
Okay.
When I get the complaint, I'm supposed to present you all with the complaint, so I have to.
Okay.
Yeah, but that's pretty much the gist of it. They didn't do anything wrong with the real estate transaction, but while they were conducting the transaction, both the affiliate broker and the principal broker were unlicensed because the affiliate broker, they didn't take a core course in time, and so their license was expired. And then the same for the principal broker, I believe. But there wasn't a complaint opened against the principal broker.
Why don't you do your recommendation?
Okay, so I recommend a $1,000 civil penalty for unlicensed activity against the affiliate broker, and that we open a complaint against the principal broker for unlicensed activity.
Move to accept council's
Second.
recommendation.
Let's divide the question. Okay, so the first motion is a $1,000 civil penalty against the affiliate broker for unlicensed activity, made by Mr. Woods, seconded by Ms. Franks. Those in favor of that motion, vote aye.
Aye.
Those opposed, vote no. That motion passes unanimously. The second half of the recommendation is to open a complaint against the principal broker for unlicensed activity. Do you have reason to believe that the principal broker didn't have a license during this period of time?
The principal broker, their license expired, and I think it was due to a failure to take a course.
But you're
it
also-
was expired.
Okay, so the motion is to open administratively a complaint against the principal broker for unlicensed activity. That motion was also made by Mr. Woods, seconded by Ms. Frank. Is there discussion on that motion? Those in favor of the motion, vote aye.
Aye.
Those opposed, vote no. That motion passes unanimously. Thank you, Ms. Downey. Number 3.
Okay. Complainant is a real estate licensee. Respondent is a real estate licensee. Complainant alleges that they had an active agency relationship with buyers. However, respondent represented the buyers and executed a purchase agreement despite the complainant's active agency relationship with the buyers. Complainant states that the purchase agreement was on a home that complainant had initially negotiated a contract for the buyers, which ultimately failed. Complainant attached a copy of the exclusive buyer representation agreement. The contract's expiration date was listed as August 31st of 2019. Complainant alleges that the respondent closed on the property with the buyers on August 19th of 2019. Respondent states that they initially received the buyer's information from a mutual friend who had listed the buyer's home. The listing expired, so the buyers were planning to list their home for sale by owner. Respondent met with buyers and gave them tips on listing for sale by owner, and also informed them of how respondent could assist with this. Respondent listed the property and it sold quickly. The buyers then continued their relationship with respondent and asked them to assist in helping them find a home to purchase. The buyers sent several properties, one of which was the property that complainant was previously unable to successfully negotiate for the buyers. Respondent reached out to the owners of the property, who informed respondent that the initial contract failed. Respondent then helped the buyers construct a cash offer with no contingencies, which the sellers accepted. The day before the closing, respondent received a call from complainant, who informed respondent that they had an active buyer's representation agreement with the buyers. Respondent confirmed this with the buyers and the listing agent. The buyers also informed respondent that they had not spoken with complainant in weeks and did not intend to continue working with complainant. Complainant filed a rebuttal stating that the respondent failed to ask whether the buyers had worked with any other agents or whether they had an active buyer's agreement with anyone, and as a result, the respondent assisted the buyers in getting around their contractual agreement with complainant. Complainant states that the buyers never informed them that they no longer wanted to work with complainant, and the property was off the market at the time they made the new offer. My recommendation is a letter of instruction regarding exclusive buyer representation agreements and exercising reasonable skill and care. It appears that the complainant's exclusive buyer agreement with the buyers was still active at the time that the respondent represented the buyers. Whether a commission is owed is a matter of contract law, and the commission is not the appropriate venue to litigate such matters. However, a letter of instruction regarding the exclusive buyer representation agreements and reasonable skill and care should be issued.
Commissioners?
Can we do a letter of instruction and give them, make them take a class? Okay, and so the minimum fine is $250? I make a motion that we have a civil penalty of $250 and require that they take a 4-hour contracts class.
Second.
Now, the motion is properly on the floor. Mr. Diaz has seconded the motion to offer this licensee a $250 civil penalty and require a 4-hour contracts course.
What's the civil penalty for? What did they do wrong?
Reasonable skill and care.
What did they do wrong? It's a good question.
Okay.
Ms. Franks?
Right.
What did the licensee do wrong?
Oh, okay, go ahead, I'm sorry.
Oh,
that's a good question.
Don't we have something that says you have to honor exclusive representation?
You do, but if they tell you, if they don't tell you they have one, how do you know they have one?
Well, you're
I mean,
supposed
that's
to
the
ask.
first thing you ask.
You're
but-
supposed to ask, and if they don't tell you, they lied to you, that's not your
So
problem.
that goes to your point, so what did they do wrong?
well,
The
so
question is, did they ask?
I mean,
Okay.
I don't think that's part of anything we have. That might be ethically a realtor thing, but I'm not sure that's legislatively a requirement.
No, I don't, there's no rule that says you need to ask about.
No, but it's skill and care.
And so the issue is that the complainant who was representing them called the respondent before the closing and let them know that, hey, I have an active representation agreement. So I just wanted you to be privy to that. And they went on with the closing anyway, because the buyers ultimately said that they didn't want to keep working with the previous agent.
So there's fault on both sides here, really. The complainant dropped the ball, or they would know these people were buying a house before 2 or 3 days before it closed and would have been involved in it.
And they would have seen the house on the market that they sold.
Yeah.
I mean, I don't have much sympathy for the original buyer's agent,
That's why I thought a letter of instruction regarding exclusive buyer agreements might be good, just so that the individual is aware of the rules and what it means when a person has an exclusive buyer agreement. I don't think a civil penalty is necessarily needed in this instance.
I was going to write a letter, it might be a letter to the first buyer's agent saying, you had a duty of loyalty to your client, and yet you didn't do anything for them. They listed somebody else. Now, I know the buyer is in jeopardy of having to pay a second commission. That's where I'd have an issue if there's a contract that says, regardless
Yeah, who's
of what
gonna
you
pay
did.
that?
Yeah.
And that's why I said that's something we won't worry about, because that's not in our purview. But the other part with the exclusive buyer representation agreement, the rules do speak to those. But, I mean, at the end of the day, it doesn't say what you need to do to end those relationships.
I was really just getting at that, it sounds like both these parties need to have a little more schooling. I was more interested, I'm always more interested in educating somebody than having a civil penalty. But I can't do that. That's why we said that.
The respondent, the only thing that this respondent did wrong, and I'm not sure this is required by statute, was ask if they were already in a buyer's representation agreement. That's the only thing wrong that I see they did.
And we don't know if they did or not.
Well, whether they
And
did or not,
they're not required to.
it's not by statute or by rule. I don't think it's required.
It's
By our
just
code of
ethical-
ethics,
code of
it-
ethics.
I know it's a code of ethics
Yeah.
thing, but I can't, off the top of my head, know about the. But I think our rules do say you have to honor other contracts, and, and you're not supposed to try to break in that. And I think I can extrapolate that. You got to ask if they're under a contract. So I don't have a problem with where Marcia's going here.
Motion on the floor is to offer this licensee a $250 civil penalty and require a 4-hour contract course in the next 180 days. Further discussion? Are you ready to vote? Since you are, those in favor of the motion vote aye.
Aye.
Those opposed vote no. Chair votes no. The motion passes on a 4-1 vote. Number 4.
2019-07-4291. Complainant is a real estate licensee. Respondent is a real estate licensee. Complainant alleges that they saw a property they were interested in and reached out to the respondent to inquire. The complainant asked how far the property extended and whether it was in a flood zone. The respondent responded to the complainant's text rudely using expletives in the text. Complainant states that respondent was unprofessional and degrading. Respondent filed a response stating that complainant text asking about information that was accessible to complainant. Respondent states that complainant did not have an appointment, and had they called and made an appointment, respondent would have emailed all the information in the property file. Respondent apologized for the language and states that their spouse has been battling cancer and they value time at home with their spouse. The respondent's principal broker filed a response stating that they had a meeting with the respondent after receiving notice of the complaint. They discussed the matter and explained to respondent that the language used in the text messages was inappropriate from both parties, and the respondent has a duty to cooperate with other agents. Respondent's principal broker states that respondent was frustrated with out-of-state agents showing up, looking at the property without making an appointment, and calling every weekend with questions. I recommended a letter of warning regarding reasonable skill and care. It's possible that this person could have interfered or caused their client to not be able to sell their home based on the way that they spoke to this other licensee. And I just think that's not in line with what the rules and regulations require.
What is wrong with people these days?
I don't know.
You know, I really take offense to this, and this happens all the time.
Preach.
I'm just, why you gotta use expletives? My mother told me that was a lack of vocabulary. So, I don't appreciate this person doing this at all. And, I've had cancer. I wasn't cussing people when I had cancer. So I don't take that as any kind of excuse for this. And I'm just really offended by it. I think they for sure have an ethical complaint here. And skill and care problem to the person that they were representing. And, if I call you with a question and you say it's all in MLS, that is not reasonable skill and care for the person you're representing. I need to sell your house, not be cussing this person, tell them to find their own information. So for that, I'd like to find this person guilty of reasonable skill and care. And I would like to assess a I started to say $1,000, but $250 fine, and this person is affiliate, yeah, and a 4-hour contracts class.
Okay, Ms. Franks has a motion on the floor that is yet to be seconded, but if it does get seconded.
They're scared to second.
It will offer, no, I want to talk to the motion in a minute. It'll offer a $250 civil penalty to the licensee and also require a 4-hour contracts course within 180 days.
Would you rather say offer this respondent a consent order rather than find them guilty?
Yes, I just want to clarify, no, they're not guilty.
Is there a second to the motion?
I'll second it.
Okay, the motion is seconded by Mr. Diaz, so it's properly on the floor. Now, Ms. Franks, what do you think's worse? This kind of response or no response at all?
This kind of response.
Just checking, I just want to see.
My daddy said you can be anything but don't be stupid. This was stupid. I'm sorry, that's an ugly word, but
It's amazing to me, to follow up on your point, how many people will not return your call, period. Which, you talk about not representing your client, that's even more, either that or they're trying to, sandbag the deal and keep both sides of the commission, which is not the best interest of anybody except maybe the agent. All right, you've heard the motion. Are you ready to vote? Other comments?
My concern is now we're regulating people's language. And I really don't want to get into starting offering penalties because people cuss.
no, the penalty was not for them cussing. That just, that's my personal opinion, because you can cuss me all day long, Bobby, but that's going to change my opinion of you.
Mark, you
But
don't know what the hell you're talking about. I don't know what you're talking about there.
The lack of skill and care is where the penalty is coming from.
But see, I could, I think John's point's right on. I mean, it's amazing how many times agents get transactions because they answer their phone and they return a call. I mean, I've had that before where I'll call somebody back and they go, "Thank you so much for calling me." I'm like, "Well, that's what I'm supposed to do." And they go, "Well, the other 7 didn't," and I'm just amazed at that. But I just don't want to get into regulating. I mean, because we get it all the time. People want to file a complaint against an agent because they were rude and mean, and I just don't want to go down that road. So that's why I'm going to vote against it.
I just also wanted to say, when we're looking at reasonable skill and care, we're talking about their abilities as an agent and what they know how to do and the different duties that they have and whether they exercised skill and care. And even if they acted, I guess, inappropriately or extreme, how they normally shouldn't have, I think that would be more of an ethical complaint, ethics version versus skill and care. But I agree with Commissioner Wood. We want to refrain from regulating behavior that is not explicitly forbidden outside of the rules and statutes.
I think Ms. Frank's logic or rationale is that this agent, regardless of what he or she said, didn't do a good job of representing the client. That's the basis of the motion.
That's the bottom line.
All right, other comments?
On the residential side, though, so many agents are getting in that aren't trained and don't know, and you just catch somebody at the wrong time, and it's where it's supposed to be. I've uploaded the files, they're there, and they want me to do their job and their job. So, there can be a little bit of personality conflict in the sense that, it's there, it's where it's supposed to be. So, I'm not defending either side, but it is hard to regulate, who steps on whose toes because they have personality differences.
All right, other comments? Let's vote. If you're in favor of the motion of offering a $250 civil penalty to this licensee and a 4-hour contracts course, you'll vote aye. Those in favor of that motion, vote aye.
Aye.
Those opposed, vote no.
No.
All right, that motion, the chair's opinion passes on a 3 aye, 2 no vote, with the chair voting aye, along with Ms. Franks and Mr. Diaz. Is that right? I got that right. All right, number 5.
Complainant is an unlicensed individual. Respondent is a real estate licensee. Complainant alleges that respondent violated the advertising rules. Complainant states that there is signage at 3 separate locations that do not have the agent's full name or the company name and phone number. Complainant alleges that there is no way of knowing whether the respondent is an agent or in the real estate business by looking at the signage. Respondent attached pictures of the signage. The sign reads, "Space available, 6,650 square feet to 24,000 square feet. Call respondent, respondent's phone number." Respondent filed a response stating that they have replaced the signs and attached pictures of the new signage. Council reviewed the new signage, and the new signs are in compliance. However, the old signs that were replaced were not in compliance. I recommend a civil penalty of $500 for each separate violation for a total of $1,500.
Was there another case that had to do with this case that we have?
There's a represent that has the same respondent.
Oh, okay.
Is there a motion to accept council's recommendation?
So move.
Motion by Mr. Bagley, second by Mr. Diaz. Discussion, just a curiosity question. Caitlin, would this have crossed your desk first before it got to legal?
It didn't in this scenario because it came in while I was on leave.
Okay. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes, and council's recommendation is adopted. Number 6.
Complainant is a real estate licensee. Respondent is a real estate licensee. Complainant alleges that the respondent advised them that there was no HOA fee on a property and also indicated this on their listing. Complainant's client made an offer based on the information that there were no HOA fees. After making the offer, respondent changed the MLS listing to indicate that there were quarterly HOA fees of $200. Complainant states that respondent did not disclose this. Complainant did not find out about the HOA fee until they called the closing agency to inquire about vinyl hood and wiring instructions. Respondent filed a response stating that the property was initially listed as a coming soon listing. All disclosures were entered into the system at that time. Respondent states that they sent all disclosures on 3 separate occasions to complainant, as complainant refused to return signed copies with the buyer's signatures. Respondent states that as a last resort, they asked the closing agent at the title company if they would include the disclosures in the closing packet. Respondent attached copies of the MLS listing, counteroffer documents, purchase sale agreement, and residential property disclosure documents, and the HUD settlement statement. Council reviewed the attached documents. The MLS listing shows that the HOA fee information was changed on September 13, 2019, the day respondents submitted a counteroffer on behalf of their clients. Complainant's clients inquired about the HOA fee on September 11th of 2019, and complainant looked at the listing in which it indicated that there were no HOA fees. I recommended a letter of warning regarding updated and accurate MLS listings.
So it's an advertising violation.
Well, I guess you could, well, I wouldn't say an advertising violation. I was more thinking of the rule that requires updated and current MLS listings. So it's more towards that. And I think this person realized that it did indicate that there were no HOA fees and then changed it and didn't inform anybody of their misrepresentation about the MLS listing and just went ahead and changed it, which wasn't right in my opinion, but that's why. But I don't think it rises to the level of a civil penalty, but more like be more vigilant in what you're uploading.
Oh, maybe y'all can help me out. I don't understand what a coming soon listing
I was
package
going to ask about that. I'm not sure.
You can put it in the MLS, it's coming soon, and we'll start showing it on X day.
But, so everything you put in there should be accurate at the time you put it in?
Yes,
Yes.
yes. All you're doing, it should work exactly like when you go to the movie theater and they'll say coming fall of 2020, and it's like a preview, and it gives you just an opportunity to kind of preview it online.
Okay.
And then a lot of times they'll say, and it's going to be coming active, and they'll say it's Friday or whatever, and they do it as an attempt to try to get buyers excited. and buyers to know that if this one's coming on Friday, maybe we want to wait about the decision on that one until I see this one on Friday.
So,
That's how it's supposed to work.
But it's being abused because people do that and they want both sides of the transaction. But now, there's a new thing coming out that the National Association of Realtors is requiring, but you'd have to be a member of that, you have to have it in the MLS if you're going to have a coming soon. You want to explain that, Bobby?
If you start marketing it at all, a property,
Calling, anything.
you've got, I believe it's 24 hours, or maybe it's a business day or something, but you've got a real short window to make it available to everybody. Because I think what has been going on in certain parts of the country, people would have networks, you might call it an office exclusive listing, where you only tell everybody in your company about it for the first week, and then you make it available to the rest of the public. Or an agent might just start marketing and telling everybody about it, but they don't make it available to everybody to know about it until they have their open house. So it basically says if you're going to tell one person, you got to tell everybody. You can't just tell select groups.
So they're adding that to the ethics part.
So here's what, I don't sell residential, but it seems to me like somebody probably filled out a property condition disclosure form of some sort, even on the coming soon listing, right? And isn't there a line in there about, is there an HOA fee or a?
Ours has that, yes.
Yeah, I mean, it's also could be possible that they didn't know at the time they put the listing in that what the HOA fee was, or if there was going to be an HOA.
Well, to me, that might be a big issue, though.
Yeah.
Especially if the owner's making the representation on the property disclosure.
You
And I
want to
guess-
find that out before you put it in.
And the thing that really was a bit concerning was that the complainant asked explicitly, just like a couple of days before it was listed as not coming soon anymore. But they asked, and then the respondent explicitly says, no, there are no HOA fees. So I don't think that you can make statements like that if you don't know for sure.
It can make you not qualify for a loan.
Absolutely.
Right, so I think that's a pertinent piece of information, and while perhaps it wasn't done intentionally to make misrepresentations, I think it's still the responsibility of the licensee to make sure those are updated and current. And if you're going to explicitly say that, then you need to also let someone know if that changes. And they shouldn't have to call and find out on their own. And I do understand they did provide the disclosures after the fact, but they need to be aware of this particular rule, which is why I think a letter of warning is warranted.
Make a motion to accept council's recommendation.
Second.
Have a motion by Mr. Diaz, seconded by Mr. Wood, that council's recommendation be adopted, and this licensee be sent a letter of warning regarding updated and accurate MLS listings. Now, does the statute ever talk about MLS listings? Or is
There's a
it-
specific statute about it.
Okay, that's good for me.
Where is that?
Let me find it. I didn't write it down on here. I can probably see.
You know, Anna?
See, I don't remember seeing where the rules or statutes address MLS listings. I do,
You ever heard
no,
of
I
that?
do with advertising, but not with MLS. I mean, I consider MLS an advertising tool.
Update.
For listing information, it's the advertising rule, 1260-02-.12. 5C.
So I take that back. It does fall under advertising.
So you want to amend your recommendation?
I mean, it still refers to MLS listings in the advertising rules. I mean, if you want me to, I will, but I don't think it's necessary.
But you want to quote that reference, 1260 dash?
1260-02-.12, 5C.
Right. Other questions? We know the motion. This is to accept your recommendation. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 7.
2019-080501. Complainant is a Tennessee resident. Respondent is a licensed principal broker. Complainant alleges that respondent changed an exclusive buyer agreement after it was executed and signed by the parties. Initially, the contract was with a different firm and licensee. However, the licensee, we'll just call them licensee A, changed firms and was allowed to continue working on the transaction at their new firm. After respondent's firm received the contract, there was a disagreement between the buyers and licensee A. The buyers no longer wanted to work with licensee A, so respondent altered their contract by putting respondent's name along with another licensee at their firm on the contract and removing licensee A's name prior to obtaining a mutual release in writing. Complainant attached copies of the purchase and sale agreement with licensee A's name listed, the purchase and sale agreement with respondent listed, and the Chancery Court lawsuit and affidavits. Respondent filed a response via their attorney stating that in June 2018, licensee A terminated their employment with their prior firm and began working for respondent's firm. Licensee A had a contract for a pre-sold lot to be built. The purchase and sale agreement was executed on April 25th of 2018, while licensee A was still affiliated with their previous firm. When licensee A transferred to respondent's firm, it was with the understanding that licensee A would continue to work on the transaction that is the subject of this complaint. When licensee started with respondent's firm, the contract was about to expire, and licensee A had not taken the necessary steps for extending the contract. Respondent prepared the extension. Respondent attached copies of the purchase and sale agreement with licensee A's name listed, an amendment to the purchase and sale agreement listing respondent as buyer's agent, and the Chancery Court lawsuit along with the mediation settlement agreement. I recommended a letter of instruction regarding exclusive buyer agreements according to Rule 1260-0236.
What was the lawsuit about?
It was between the builder and the buyers, because I guess the contract stated that, well, they were suing for specific performance on the buyer side. I'm sorry, the builder side.
Do you agree that the principal broker changed signatures?
I mean, they wrote it in there. On the form, it just says change from licensee A to licensee B and C. They just wrote it in there on the amendment.
So they're changing the designated agent? Or are they changing the brokerage name?
They changed let me look at the form and make sure I'm saying that right. Okay, so
This one was very confusing, I thought.
the complaint was confusing. So it is a bit convoluted. It's more confusing because the licensee was a part of a different firm before and then switched to the respondent's firm and was supposed to keep working on the file. But then the buyers didn't want to work with that particular licensee anymore, and so they just didn't go through the proper channels to change the buyer or the licensee's name, and they just wrote on here It says add licensee B as selling licensee and licensee C as co-selling licensee. And it's on an amendment to purchase and sale agreement. And they actually did type it in here, but it doesn't contain the signature of the original licensee. It just has the buyer's signatures.
So the principal broker, with the authority he or she has, replaced a licensee with two other licensees.
Right. Well, it was
That-
the principal broker and one of the other licensees from that principal broker's firm.
I think that's okay.
Yes, the
Okay.
broker's commission, so
Okay,
they can do
that's
what they want to with it.
I just want to make sure this wasn't a situation where there needed to be an additional step involved in changing these licensees on the forms. And if you all, as principal brokers, have done this type of thing before, that's fine. But I didn't think it was worth a civil penalty, but I did think maybe being refreshed about the rules regarding exclusive buyer agreements might be good.
So you did say that the broker used an amendment to the PSA,
There is an amendment, yes.
so,
Move to dismiss.
second.
Okay.
Motion by Mr. Wood, seconded by Mr. Diaz. This complaint be dismissed.
And I guess for number 8, it'll be the same thing, because it's the affiliate broker for number 8.
Want to combine the two, Bob?
Not yet. Oh, you do? That's your motion?
I'm good with that.
Well,
Second.
Well, the motion now is to dismiss both cases 7 and 8. Discussion. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 9.
All right, number 9, 2019-083811. Complainant is a Tennessee resident. Respondent is a real estate licensee. Complainant alleges that the property was listed as a site-built home. However, they discovered that the seller/builder is not a licensed contractor and that no permits were pulled for the property construction. The home was actually classified as a manufactured home rather than a site-built home. Complainant attached a copy of the MLS listing which classifies the home as a site-built home. Respondent filed a response stating that they knew the property was a manufactured home because they were involved in the purchase of the property when the seller acquired it. When the seller was ready to list the property, they stated that the property had been built new from the foundation to the roof. Respondent states that they listed the home as a renovated manufactured home on a permanent foundation. Respondent states that another licensee suggested that they list the property as a site-built home due to the fact that the seller expressed that they built it all new from the foundation up to the roof. Respondent alleges that they checked with several other licensees in their office and a lender about whether this would be appropriate, and they all agreed that it was appropriate to list the home as site-built. They
I
advised.
just want to point out, they ask everybody except the most important person, the broker. So,
They advised that it
Amen.
would be, they advised that it would be up to the lender when the appraisal was completed as to whether it is truly a site-built home. Respondent changed the listing after consulting with others and did not feel they needed to disclose this information because they did not believe it was pertinent to the purchase of the home. Respondent states that the appraisal was completed on September 12th of 2019. Following the appraisal, the complainant walked away from the transaction. The respondent discovered that the complainant left the transaction because the home inspection, not the appraisal, listed the property as a manufactured home. Respondent contacted the lender, who confirmed that the home was appraised as a site-built home. Respondent states that they did not deceive anyone and no latent facts were withheld from the potential buyers. Respondent states that the property is back on the market as a manufactured home. However, after consulting with other appraisers, no one can tell them definitively whether the home is site-built or manufactured. Respondent attached the receipt for the permits, a copy of the MLS listing of the property as a manufactured home on a permanent foundation, an affidavit of affixation, and a copy of the home inspection report listing the property as manufactured. I recommend a letter of warning regarding 6213-402C5.
I think that number's wrong. It should be 403.
403. Oh, let me see.
What do you think, Mr. Wood?
I think this agent is wrong as wrong can be. I mean, they flat lied is what they did.
Yeah, they did.
I would rather make a motion of a $1,000 civil penalty for not exercising reasonable skill and care. And I'm also,
He's mad now.
I'm mad at the broker, or I'm mad that they didn't know to contact the broker. It sounded like they contacted everybody in town except the broker. I mean, that makes you wonder, is the broker even available?
Yeah.
They didn't want the answer from the broker.
They didn't want the answer from the broker because then they'd have to sell it as a mobile home.
Yeah.
And it is 403C5,
Okay.
sorry
Right.
about that.
Okay, well, my motion is $1,000 civil penalty for exercising reasonable skill and care.
Any
Second.
classes? Wait a minute, what? These people need some teaching.
Want to make them attend commission meetings? You want them to do that?
Oh, that's too harsh.
They used to work well.
Yep. I don't know of anything that would hit upon this. So I just stay with the civil penalty right now.
The motion I have on the floor is from Mr. Wood, seconded by Mr. Diaz, and if passed, would offer this licensee a civil penalty of $1,000. Discussion? Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passed unanimously. No.
No.
There's education, but it's writing a check. I mean, you learn a lot sometimes from writing a check.
Some people call it cost of doing business, too, though. I don't like that.
I know.
I call it a commissionectomy. So-
Number 10.
Okay, so number 10 is represented.
So,
29, go ahead.
I'm sorry, excuse me. Go ahead and read the case number.
Okay, it's 2019-06-8881. This was, I don't know if you all remember, but this is one where we were trying to determine whether that this respondent issued a rebate for the real estate transaction to his client or to their client. So I contacted this respondent and asked them, I asked the respondent about the check that they sent, and the respondent stated they sent the complainant a money order. Respondent states that the complainant didn't deserve any money, but they agreed to list the complainant's home for $500 less and refund the money once respondent was paid from the transaction. Respondent states that this was a verbal agreement with complainant, and respondent states that their commission was paid to their brokerage, and once their check cleared, they purchased a money order and mailed the money order to the complainant. So I recommended, my new recommendation is a $500 civil penalty for violation of 6213-302B.
So this is clearly a case of a licensee paying somebody directly, but is it considered a commission? I mean, or is it?
No, because it wasn't.
For rebating.
It was a rebate,
Yeah.
because it was paid to someone not licensed.
Right, this was their client who is not a licensed.
None of that's in dispute. The question is 500 enough?
It's not.
That's
Mr.
not up to
Wood.
me.
I make the motion, it's a $1,000 civil penalty for rebating a commission.
Motion by Mr. Wood is seconded by Mr. Diaz. Is there discussion? Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 11 and 12 effectively, right?
Yes.
Okay, so which one are we going to say is duplicate?
We're going to go with number 12 as the duplicate and keep number 11.
Let's do this. Is there a motion to dismiss number 12?
So moved.
It's a motion by Mr. Diaz, seconded by Mr. Bagley. Let's vote. Those in favor of that motion, vote aye. The motion passes unanimously. Now back to 11.
Okay. So this was the this was the situation where the complainant signed their client's name on the real estate transaction forms without obtaining their permission to do so, and their clients didn't state that they allowed them to do this, so their principal broker reported them.
So if you go to the page 11, at the top, originally the commission had a contracts course and $500 civil penalty. Now you have new information.
Oh, the new information is that the second complaint, well, there was an administrative issue in which the complaint was submitted through centralized twice, creating two separate complaint numbers. The two complaints were issued to two different attorneys for review and presentation to the commission. After presentation to the commission, during the initial presentation, which is number 11, the commission voted to issue a 4-hour contracts course to be completed within 180 days above and beyond what is required for licensure, and a $500 civil penalty. So my new recommendation is for the commission to keep number 11, the complaint from number 11, which is 2019-066631, and the discipline that was issued and dismissed the subsequent complaint, which has already been done.
So why do we need to vote on it again?
There's no motion necessary. The chair.
Oh, just, you all already voted to dismiss number 12, so we're good.
Let's go to number 13.
Okay. Number 13, 2019-052701. So then, I'm going to just skip down to the new information. Council discovered that the complaint was opened against the incorrect licensee, as there were multiple licensees with the same first and last name. The complainant filed the complaint listing the wrong middle initial for the complainant. As a result, this complaint should be closed. So the 2019-052701, and that person was not licensed at the time, but that was the wrong complainant or respondent.
Okay, so we have two parts to this. Is there a motion to dismiss complaint number 13?
Move to dismiss.
Thank you, Ms. Franks. Motion by Ms. Franks, seconded by Mr. Diaz, that case 13 be dismissed. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Now, is there a motion to open a complaint against the correct licensee for
So
unlicensed
moved.
activity? Thank you,
Seconded.
Ms. Franks. Ms. Franks moves to open a complaint against the correct licensee. Mr. Diaz seconds that motion. Is there discussion on that motion? I hear none. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 14.
So the new information, the respondent firm recently reapplied for licensure for expired status. The original complaint alleged that the firm was unsuccessful in dissolving a timeshare interest on behalf of the complainant. Regulating the dissolution of a timeshare interest by a timeshare settlement company does not fall within the jurisdiction of the commission. In addition, from the prior investigation, there was no evidence to suggest that respondent is the actual responsible party. The complainant even states that they have not been directly misled by the respondent. So my new recommendation is to dismiss this complaint altogether.
To accept council's
Second.
Motion by Mr. Diaz, second by Mr. Wood, the complaint be dismissed per council's recommendation. Before we vote, whose responsibility is this issue?
The settlement, to regulate the
As-
timeshare settlement companies.
Regulating the dissolution of a timeshare interest.
I'm really not exactly sure if this should be something that Consumer Affairs handles or if their only recourse would be to file a civil lawsuit. But it's not something that we can help this particular complainant with, because it's like you all were talking about earlier with these companies that promise to get you out of these timeshare contracts, but they really can't do anything if they haven't violated any of the rules and regulations. So I'm not sure who would be responsible.
Surely there must be some entity in the state a consumer like this can turn to for help.
I would think Consumer Affairs, but
Yeah, these typically get filed with Consumer Affairs as well.
Would this be recommended or forwarded to Consumer Affairs?
it did go to Consumer
Okay.
Affairs, but then they sent it to us, and it's just kind of been a back and forth.
See who else we can send it to. Erica, who do you like? Cosmetology or motor vehicles? Somewhere?
Yeah, send it to motor vehicle.
Yeah, that's a motor.
Straight to the DA's office, really. Attorney General.
Something geologist.
Yeah, the geologists. They don't do much.
Not
Soil
land
scientists.
surveyors, not
See,
geologists.
and the timeshare people love this because they got us so confused. You can file a complaint in the state of Tennessee and nobody knows where it's supposed to go. That's pitiful.
And they have all their documents signed. All right, the
We
motion.
need an interpretation on that then. I mean,
Well, this is time, these people are asking us to get them out of their contract.
We can't do that.
We can't do that. Most people are asking, telling us they were misled, which we can address, except they have all their documents signed.
we've been mad all day, haven't we?
Not yet. We got another half a day to go.
What's this "we"?
Yeah.
It's the end of the table.
Whether I've said it or not, I'm saying Mr. Diaz made a motion to accept council's recommendation and Mr. Begley seconded it. Is there discussion on the motion? Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you, Ms. Downing. Good work. Ms. Matlock, number
Number 15,
15.
2019-080441. Complainant is a Tennessee resident. Respondent is a licensed real estate firm. Complainant alleges they entered a 12-month listing agreement with respondent in September of 2018. On or about September 22nd, 2018, complainant states they received a listing agreement indicating a cooperative agent commission of 3%. Complainant also alleges on July 24th, 2019, they also received a copy of the agreement listing the same. Upon expiration of the contract, complainant discovered the MLS showed a 2.5% buyer's agent commission. On September 23rd, 2019, agent sent another copy of the listing agreement indicating the 2.5% cooperative agent commission. Complainant alleges respondent's agent changed this agreement without their knowledge, and this change demotivated other buyers' agents. Complainant states they requested a full release from respondent's agent, along with the right of first refusal during a contract negotiation, both of which were denied. Respondent answered the complaint through their attorney. Respondent states this matter is a result of independent and unknown actions of the licensees that is no longer associated with the firm, but concedes respondent's agent was an independent contract real estate agent with their firm. Respondent states they requested a copy of the listing agreement from complainant and respondent's agent. Respondent states their agent informed them of the numerical error and delivered the incorrect version of the listing agreement to respondent and used this agreement to complete the MLS advertisement. Based on the information provided by respondent, counsel recommends this matter be dismissed against respondent and an administrative complaint be opened against respondent's agent.
So moved.
Second.
Motion by Mr. Diaz, seconded by Ms. Franks, the council's recommendation be adopted, the complaint be dismissed, and a second complaint be opened against the respondent's agent. Discussion?
So the respondent's answer is basically saying the agent did it, we didn't know about it? Or,
Yes, but it was the principal broker that answered. This complaint was open against the firm.
okay,
And so I thought that
Okay.
the appropriate person would be the agent.
okay, I'm good.
So the complaint's not going to be opened up against the principal broker if this motion passes.
It's going to be open against the agent,
The former agent.
agent, correct.
And we can reserve the right, if we see something in that complaint,
Yeah.
to do something to the principal broker if necessary.
Other discussion? Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 16.
Okay, so 16 and 17 are against the same respondent, but two different complaints. Number 16 is 2019-080791. Complainant is a licensed attorney and licensee. Respondent is a licensed property management company. Complainant represents an individual that holds a real estate power of attorney. Complainant states their client entered into agreement with respondent and that the agreement was signed by an agent of respondent. Complainant's client paid rental payments in 2018 and 2019. Beginning in 2016, respondent failed to properly disperse rental payments to complainant's client. In all, complainant's client is owed over $38,000 and required to pay taxes on payment they failed to receive. When confronted with the situation by complainant's client, respondent's agent acknowledged the payment failure and forwarded a check later deemed to have insufficient funds. Complainant's client demanded return of the security deposit upon termination of the agreement and has not received payment. Respondent did not provide a response. Correspondence was forwarded to respondent's address on file and their principal broker. Both documents were returned. Additionally, respondent was closed on November 20th, 2019. Council contacted complainant's attorney and confirmed their version of events. Complainant's attorney also provided council with documents containing the specific transactions made from complainant to respondent in a detailed timeline of events. Complainant's attorney states their client has yet to hear from respondents and is experiencing difficulty locating respondent. My recommendation for this one was to discuss. So this one is very similar to number 17. We have an individual that's a principal broker for a firm. Their license is expired, their firm has been closed, and we can't find them. So what they've done here is obviously a violation of the rules. They haven't responded, but I'm not sure what your recommendation would be in this particular instance since we're having difficulty locating the person.
Would this not be one that we might, I mean, because this looks like criminal charges to me.
It is
to
very,
the-
no,
to
I
send
think
to the
it's.
DA.
Right, there are a lot of recommendations. One of them, I actually spoke with complainant's attorney about that to ask if they had considered referring this to the DA. And they stated that that was a course of action that they would look at, but wanted to file it with the commission first. And so I think that this complaint is best suited for the DA, as this is clearly criminal activity that's going on here, and we cannot find them with our investigators, so maybe the police or DA will be able to find them.
Because they have lots of people that could do more in-depth investigating.
Right, but
So we could find this person guilty of some things and assess them a civil penalty, whether we find them or not, and at the same time turn it over to the DA's office, because it sounds like to me the DA office is wanting that kind of information from us, that yes, the Real Estate Commission does find fault in this person, and they can use that in court also.
Right, so, but my recommendation would be, as we've already discussed, we can't find this person, so we can only recommend discipline and receive, we have to get service from the person in order to institute any discipline. So this firm has already been closed, so my recommendation was going to be to close and flag and refer to the DA's office. Because I think that's all that we can do in this particular instance. I'm to my knowledge, a lot of people are looking for this respondent, so it's not just the Real Estate Commission.
Well, there's a line, is what you're telling me?
There's not a line for sure, but I think since their license is already expired and their firm is closed, the appropriate thing would be to flag it and then refer to the DA's office.
Can I just, Caitlin,
Yes.
this is not a case that you and I have talked about.
No.
Okay. What about the principal broker, Anna?
It's the same person. The principal broker is, so
they can't find.
Well, but the complaint was opened up against
The firm.
the firm and an affiliate broker.
sorry, hold on one second. I don't know who the former principal broker is. Let me check real quick, sorry.
Could be as quick as a social media search.
The principal broker?
The respondent that we're looking for. Try that, okay.
Sorry, one second. 19.
But at the same time, we need to do the same thing to the principal broker, right?
Maybe, depends
Okay.
on what they say here. Come back here to smoke every.
Smoke and break every hour.
So I don't see a principal broker that is listed with the firm. Can we, Caitlin.
If you've got their name, can't you go
I
verify?
misspoke. This was, I was thinking of a different one, but this is,
So at this point, I
One that you would
recuse
need to
myself
recuse.
from this discussion.
Okay, if there's only 4 of us, can we?
It's okay, I'm
abstain?
still present.
Okay.
My vote will be a recusal.
Okay. Somebody's on fire.
Vaping.
Okay, so it looks like an additional complaint has been filed by the principal broker of this firm.
By the principal broker?
Sorry?
Or against the principal?
Against the principal broker.
Okay.
But your recommendation for this case would be to close and
My
flag.
recommendation is to close, flag, and refer to the DA.
Motion to accept council's recommendation.
Second.
All right, discussion. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. Chair recuses himself from this particular vote. Let the record reflect that, please. Next.
The next one is number 17. 2019-081811. Complainant is a Tennessee resident and lessee of respondent. Respondent is an expired affiliate broker. Complainant states they leased the property through respondent and provided notice and vacated the premises on June 29, 2019. Complainant states respondent has failed to return their deposit of $1,675. Complainant has been unable to contact respondent as all numbers have been disconnected. Respondent failed to provide a response. This matter was sent out for investigation. The investigator visited the location on file for respondent and found that respondent has listed this address but does not live there. The current inhabitants do not know respondent or how to contact them. The investigator also visited respondent's business location and found the business had gone out of business and was vacated in September 2019. Also, the business stated the police and various other individuals had visited respondent's location several times due to fraudulent activity. Ultimately, the investigator was unable to locate respondent. So this is the affiliate broker of the firm that we just discussed. That's license is expired. So my recommendation would be the same as the previous one, would be to close, flag, and refer to the DA's office.
Motion to accept council's recommendation.
Second.
Mr. Diaz makes a motion to accept council's recommendation. Ms. Frank seconds that motion. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Chair recuses himself. Motion passes 4 aye, no noes. Number 18.
Okay. Number 18 is 2019-082031. Complainant is anonymous. Respondent is a licensed affiliate broker. Complainant states respondent does not have a vacation lodging license to manage short-term rentals. Complainant provides a screenshot of a message purported to be from respondent that states they own, manage, and sell short-term rentals. Furthermore, respondent states as a licensed real estate agent, they are not required or allowed to hold a dual license with a VLS license as their affiliate broker license. Allows them to do all real estate activities, including property management of short-term rental. Respondent says they have communicated with 3 different individuals from Trek that stated they do not need a VLS license, nor are they allowed to hold a dual license as an affiliate broker. Respondent provides screenshots of their call log and an email stating such. Counsel believes this miscommunication and confusion is a result of this complaint being filed. While counsel believes respondent is required to hold a separate VLS license, counsel believes respondent acted upon mistaken information disseminated. Therefore, counsel recommends a letter of instruction be issued to respondent informing them of the licensure requirement for a vacation lodging service. Letter of instruction is my recommendation.
Move to accept council's recommendation.
Second.
Can we also require them that they got to get their VLS license like within 90 days or something?
They have worked to get their license since then.
But they've got it now?
Yes, I believe so.
Okay.
Motion is to accept council's recommendation. Ms. Franks made that motion. Mr. Diaz seconded it. If you're in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Was it
Now-
actually Trek employees they talked to, or is it call center people?
So they talked to 2 different call center individuals, and then one person that was a Trek employee. But I will take responsibility for that. There is miscommunication on my part to the Trek employee. At the time, we were looking at whether you needed to hold a separate VLS license, if you could hold a designated agent license and an affiliate broker license, and there was miscommunication on our part, so.
So can you?
You can hold both, yes.
Would
that's
you be
correct.
required to?
If you are doing vacation lodging service, yes.
You can't do that with your affiliate license?
No, because it's completely separated.
Okay. So it's like I could have a barber license and a realtor license then?
Correct.
Okay.
So I may want to reconsider what we just passed. Why do we need to send a letter of instruction if he's already got the
Just
license?
to inform them of what had happened, just like what the vacation lodging service, it's to explain the difference between vacation lodging and
Okay.
broker.
Number 19.
Number 19, 2019-083631. Complainant is a timeshare owner. Respondent is a timeshare registration exempt company. Complainant alleges they were required to attend it. Do you want me to read it or just skip
Hope
to
I
the
want you to skip that short
Okay.
sentence.
Respondent did not submit a response. My recommendation is a $1,000 civil penalty for failure to respond.
Move to accept council's recommendation.
Second.
Ms. Franks motions and Mr. Diaz seconds to accept council's recommendation. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 20.
Number 20, complainant is a licensed principal broker. Respondent is unlicensed. Complainant alleges respondent is representing themselves as the owner of a property and representing the seller of the property without a license. Additionally, complainant alleges respondent has forged electronic signatures on disclosures in the seller's absence. Complainant states respondent completed a property disclosure form in respondent's name representing themselves as the owner when the property record indicates otherwise. The electronic signatures have the same ID underneath them. Complainant also states the confirmation of agency form lists one of their agents as the seller, and respondent informed complainant the agent was a friend of theirs and supposed to sell the house to respondent. Complainant contacted the principal broker of the firm respondent associated themselves with and has not heard any further correspondence. Complainant provides a copy of each document referenced as support. A response was sent to the principal broker of the firm respondent listed themselves with. The principal broker states respondent is the personal assistant of the owner of the property and has been granted permission to sign documents to list the property on their behalf. The principal broker states the big discrepancy here is that their system sent out a seller's disclosure form, but based on the fact that the owner never lived in the property, the owner is exempt from completing the form. The principal broker also states a new document was sent to the owner and contains a wet signature. Based on the information provided, counsel finds no evidence to support the principal broker's assertion that respondent was permitted to act on the behalf of the owner. According to the confirmation of agency form, the owner is listed as the seller and the principal broker is listed and signed as the listing licensee, yet the box is checked, the seller is unrepresented. Additionally, the forms utilized contain the name of the principal broker at the bottom of the page. Council recommends respondent be assessed a $1,000 civil penalty for unlicensed activity.
Move to accept council's recommendation.
Second.
Wood makes a motion, Mr. Diaz seconds, that council's recommendation be adopted, and this licensee be offered a $1,000 civil penalty.
I have a question.
Yes, ma'am,
What's a wet signature?
It's ink
Real one.
as opposed to
versus
digital.
an electronic signature.
Yeah.
Well, that's one thing it could be. It could be,
Wet.
signed with a tomato or something, I don't know. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 21.
2019-084361. This complaint is related to the above complaint. It's, the respondent is the firm. Council recommends this complaint be dismissed against the firm and administrative complaint be opened against the principal broker.
Move to accept council's recommendation.
Second.
Ms. Franks makes a motion to accept council's recommendation. Mr. Diaz seconds. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 22.
Number 22, 2019-084551. Complainant is a licensee. Respondent is a licensed principal broker. Complainant alleges respondent repeatedly advertises with inadequate information on their billboards, videos, websites, and radio advertisements. The violations include lack of phone number to the brokerage firm, no local phone number, and a phone number that does not match the phone number listed with the commission. Complainant provides images of respondent's billboards and website. Respondent answered the complaint stating their marketing company missed including the phone numbers on the billboards, and they are working to correct this immediately. Respondent states they should have the billboards in compliance within the next few weeks. Respondent also denies allegations related to their video and radio advertisements. Based on the information, it is clear respondent is in violation of Tennessee Comprehensive Rule and Regs 126DO2-1213-12-3B and recommends a civil penalty of $500. That's the advertising rule that states what you're required to put on your information.
To accept council's recommendation.
Second.
And there's only one billboard, right?
There are multiple billboards.
Okay.
You have a count?
I could look and see. It looks like this person just went around driving looking for the billboards, so I don't know how many there actually are.
Or at least that many that they have pictures of.
Right.
Wow.
So I'd like to know how many
Okay.
pictures you have.
Hold on 1 second.
That's thorough for the complainant.
Kind of offended.
Wow.
Complainant is a licensee.
That's why you're nice to everybody.
Well, that's why you play by the rules.
That too.
Rule breakers do get caught, especially when they're big ones. And they're on TV and everything. Video.
So I have, oh, wait, sorry, they submitted an additional pictures. Five pictures.
Does that make a difference in your motion, Ms. Franks?
Did I make the motion?
I made the motion.
Mr. Diaz, excuse me, does that make a difference in your motion?
It should.
Is it pretty clear they're all different billboards, or like maybe two pictures of the same billboard? Or?
It's clear they're different.
Okay.
Based on the pictures, they're in different locations.
And usually it's a $1,000 fee, not a $500 fee.
Not for the first offense.
Yeah.
The first one is $500.
Okay.
Was the count, you say the second billboard was the second one?
First one's 500 and the other four could be 1,000.
No, I wouldn't do that. It could be, though.
I think we had somebody, when Kelsey Bridges was here, and I remember her bringing one up, and they had multiple billboards, and I think we just got them the one time, the $500. I don't remember us, because I think I remember asking, and Kelsey was real dodgy about how many billboards there were, but there was multiple billboards. So I don't know. I like to smack them as many times, but on this one, I'd kind of say hit them the $500.
I'd just like to be
Because we've
consistent.
done it the other times too.
We
So.
had something today that it was 500 times 3, that was 1,500.
We did.
They had 3 violations on the same sign.
I thought it was 3 different signs.
3 different signs.
Oh, was it?
Oh.
Well, I thought it was 3, well, they had 3 violations on 3 signs, I think, so. Okay.
So I'll
I'm going to-
maintain my motion.
I'm going to make the motion who says his original motion stands. Now, any member of commission, and it was seconded by, I forgot to note that, was that you, Marcia?
Well, maybe I seconded it. I don't know.
But you're welcome to offer a substitute motion if you're inclined.
I just don't think $500 is enough, and that, again, goes to just cost of doing business. And we know there's multiple signs. They're responsible, even though the marketing company made the mistake. I can tell you, when I have a marketing company do something, I approve what they do, and they want me to approve what what they're doing for me.
They make you sign off on it. They don't.
That's right.
You don't wing it when you're doing billboards. They make you sign
No,
it.
because they're very expensive.
Yeah.
Billboards are very expensive. And so we know there's 5 instances. So,
Grand.
so could we do $1,500 since there's 5 of them?
Would you like for that to be a substitute motion?
I would like for it to be a substitute.
Is there a
motion.
second to the substitute motion which would offer a civil penalty of $1,500?
Because it may be cheaper at $1,500 to just leave them up than it would be for the billboard company to now take them down. I can assure you it is much cheaper.
Mr. Bagley?
My question is just back to consistency. So earlier it was 3 times 5, which is 1,500. Now it's 5 times 5, which should be 2,500, but we're just kind of winging, making it 15.
I'm getting peer pressure here.
No, no,
I
I'm
like
just
for it to be
asking.
2,500.
I'm just asking
It's a
how
fair
we stay
question.
consistent if we don't have a formula. So, I'm just asking.
Good
It's the
question.
same sign in 5 different places, if that makes.
So I don't have a second to your substitute motion at this point. Why don't you consider a substitute motion that says $2,500?
Okay, I will make a substitute motion for
Is
$2,500.
there a second to that?
I'll second.
Mr. Bagley seconds that motion. So that motion now is properly on the floor. So the substitute motion is a offer of a civil penalty of $2,500. If this motion passes, and that's what'll happen, if it fails, we'll go back to the original motion, which was a $500 civil penalty. So, everybody understand the game plan? Any discussion?
And just remember that other person that had the 3 for 500, this is an important vote here.
Are you, lobbying you'd like to do before?
Just saying. We want to be consistent.
All right, we're ready to vote, I sense. If you're in favor of offering a $2,500 civil penalty to this licensee, please vote aye.
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 If you're opposed, vote no.
No.
All right, the chair determines that the motion passes on a 4 aye, 1 no vote. Mr. Wood voted no. Number 22.
Number 23,
I'm sorry, 23.
Maybe.
That's right, that's what it is.
2019-082681. Complainant is a Tennessee resident. Respondent is an unlicensed individual and property management of the apartment complex. Complainant states while doing research, they realized that none of the employees or employers of respondent's company are licensees in Tennessee. Complainant is concerned about this activity and its impact on respondent's customers, particularly their child that is suffering from health issues, vandalism, and uncleanliness. Complainant provided counsel a copy of their lease and several other correspondences with respondent. Respondent answered the complaint through their attorney. Respondent states complainant's child entered a lease with an apartment complex community which provides private residential housing to college students at a certain Tennessee university or college. Respondent is the general manager of Respondent LLC. Respondent's attorney argues that respondent falls in to the exemption provided with TCA 62-13-104A1E, as their duties are limited to supervision of the facility and its employees, such as maintenance and office clerical personnel, exhibition of the apartment units, leasing and collection of security deposits and rental amounts. Respondent states they do not negotiate security, deposits, or rental amounts or lease terms. However, the entity in which respondent is employed by is not licensed with the commission. Furthermore, as has been determined by the opinion of the Attorney General, the ownership exemption of TCA 6213-104A1A only exempts the owner itself, not the owner's agents, officers, or employees. Therefore, council recommends respondent be assessed a $1,000 civil penalty for unlicensed activity.
Move to accept council's recommendation.
Second.
All right, you've heard the motion, the proper second. One question, Anna. So the
Yes.
next complaint is also related to this.
That's correct.
Now, who's unlicensed in the first complaint? Who's unlicensed in the second? The LLC, is that the first complaint?
So the first, number 23 is a person, and the next one is, hold on a second.
Second one's an LLC.
Yes. The second one is the LLC.
So this first vote is related to the unlicensed person doing license-required
So you
activities.
can get the person and the LLC?
There were two separate complaints opened.
All right,
So I guess the one question I do have is, this complaint is for one specific person, but it doesn't address the potential of the other employees who may be unlicensed as well?
Right, I don't have any information about those employees. I just have this person's information, and the attorney for respondent confirmed that they are the property manager for this residence, so.
other questions? The motion is to accept council's recommendation. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. And so without reading number 24, your recommendation has to do with a $1,000 civil penalty. Oh, we're opening, I'm sorry. Go ahead.
Number 24 is 2019-082191. This complaint is related to the previous one. Complainant is the same individual and respondent is an unlicensed limited liability company. Respondent states the complex in question is owned by a separate limited liability company and managed by a separate limited liability company. Respondent's entity is not associated with the complex in any manner. Therefore, council recommends this complaint be dismissed against the respondent as they are not the proper entity. However, council recommends an administrative complaint be opened against the limited liability company that manages the complex for potential violations of unlicensed activity. So it's just, okay, yep.
Got it.
If you have any questions, let me know.
Motion to accept council's recommendation.
Second.
Motion by Mr. Diaz, seconded by Mr. Wood. The council's recommendation be adopted and this complaint be
And we're doing those
dismissed.
two things together.
Correct. And at the same time, we dismiss this complaint, we open an administrative complaint against the managing LLC. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. 25.
Number 25 is 2019-080521. Complainant is anonymous. Respondent is a licensed affiliate broker. Complainant states they have received multiple letters from respondent and does not believe it is legal for respondent to offer gift cards to solicit real estate services. Complainant provides a copy of respondent's letter which states at the bottom, P.S. If you refer us to anyone who signs a listing agreement, we send you a $200 Visa gift card to your favorite spot or store. Respondent states they are not in compliance and that Rule 1260.02-.33 and claims gift cards are specifically mentioned as an acceptable form of consideration and they are operating and soliciting businesses within the rules. Respondent also states sending direct mail to solicit listings is not illegal or unethical and requests this matter be dismissed.
Let me stop right there and just kind of say, I don't think it's a gift card issue like they're wanting to say. This is really, they're paying referral fees to unlicensed people. And I think they're trying to confuse the issue with the gift card thing, but they're paying referral fees for license, for stuff. And so I think this is pretty severe. I mean, there's certain things that us agents get beating our head in pre-licensing. You don't mess around with earnest money. You don't do rebates. I mean, and this is one of them. And so I'd like to make the motion that we have a $1,000 civil penalty for paying referral fees to unlicensed people.
Second?
All right, the motion on the floor offered by Mr. Wood and seconded by Ms. Frank, if passed, would offer this licensee a $1,000 civil penalty. Discussion? All right, then let's vote. Ms.
I'll ask afterwards. I guess it's just the person that filed the respondent said that this fell under the gifts and prizes rule, which is on page 95 of the book. And I thought that it did not fall under this rule because it says a licensee may offer a gift, prize, or other valuable consideration as an inducement to the purchase, listing, or lease of real estate only if the offer is made. And so my interpretation, I wanted to see if this is, I didn't know how this is normally done in practice, but when I'm reading an inducement, I'm reading it as an inducement to you being the person that is listing, not to any person you don't know. So it would be a referral fee, correct?
Yeah, an inducement is, I say, if you come buy a house from me,
Right, I
then
will
I'm
give
going to
you-
give you a $200 gift card, okay? But the referral is, if I say to Ross, if you can convince Anna to buy a house from me, I'll give you $200, okay?
Right, I just
That's-
wanted to
yeah.
make sure, because I know we've talked about gift cards before, but this sounded not like it was a gift and prize and referral fee. Okay.
Very good description.
That was my one. I'm done for the day.
It's a teacher in him.
All right, the motion on the floor is to offer this licensee a $1,000 civil penalty. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Represents number 26.
Okay. Number 26 is 2019-02-0081. So the new information is the respondent in this matter was sent a consent order following the meeting. This consent order was returned undeliverable. Following this, council ran a clear search on both the entity and the individual responsible for the entity. Per the report, an additional search, including a search of the Secretary of State's website, it appears the respondent's business has been closed since at least 2018. Therefore, council recommends that this matter be closed and flagged.
Motion to accept council's recommendation.
Second.
Yes, makes a motion to accept council's recommendation. Mr. Wood seconds that motion. Is there discussion? Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 27.
Number 27, 2019-006071. The new information, it appears that complainant spelled respondent's name incorrectly in the above-mentioned complaint, and therefore the appropriate complaint correspondence was not received by respondent, who is licensed with the commission. Based on this information, the response received by respondent, council finds no violations of the rules and statutes and recommends this matter be dismissed.
Motion to accept council's recommendation.
Second.
Discussion. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 28.
Number 28, 2019-018141. After failing to serve respondent, council sent this matter out for investigation to obtain service of process. After a search, the investigators were unable to locate respondent. Recently, council was notified by an outside entity of the activity concerning the respondent that is experiencing similar issues. Therefore, council recommends this matter be closed, flagged, and referred to the District Attorney General for potential prosecution. So my recommendation is close, flag, and refer to the appropriate District Attorney General.
Move to accept council's recommendation.
Second.
Wood makes a motion, which Mr. Diaz seconds, so it's properly on the floor. So could this, the outside entity, could they provide new information about where this unlicensed entity is?
So the person in this complaint is a person, and the entity is another company, and we already sent this out for investigation. We couldn't find them. They are unsure of where their whereabouts are, but they only gave another estimation of possibly where they were. So we recommended, if we referred to the DA, that they would use, better.
Okay. Let's see, if this motion passes. If you're in favor of referring this case to the district attorney, the appropriate district attorney, please vote aye.
Aye.
Those opposed, vote no. The motion passes unanimously. Do we ever, we don't do this often, but when we send stuff to the DA, do we ever get any follow-up from them that says, they say they're going to pursue it, or there's been resolved, or?
I have not seen any, so I'm not sure. But I know sometimes like an official referral letter may help spark an investigation possibly. So the next we have are
Don't make me mad again.
complaints 29 through 48.
Don't get mad.
So I'm going to read these into the record really quickly.
Tell us your recommendation before you do.
Okay, so the recommendation is going to be to close and flag and refer to the appropriate District Attorney General office and formally refer to the Attorney General. So,
Do they all happen in the same county?
no, so that's why.
So you got
we
different DAs?
Right, so that's why we refer to the appropriate
Okay.
District Attorney. So, you read you don't need the new information? Okay. So I'll read the complaint numbers: 2018-050491, 2018-062551, 2018-052631, 2018-059791, 2018-061891, 2018-064691, 2018-076581, 2018-077591, 2018-078821, 2018-081191, 2018-088311, 2018-061841, 2018-064861, 2018-065711, 2018-072211, 2018-082011, 2018-060091, 2018-065731, 2018-088241, and 2018-062551. And my recommendation for all of those is to close and flag and refer to the appropriate District Attorney General office and the AG.
Who to
Motion.
accept?
Second.
Motion by Ms. Frank, seconded by Mr. Diaz, would accept council's recommendation. Since the perpetrator apparently is in Mexico, who is the appropriate DA? Does it,
So
Where the crime was committed?
we would need to, where the property or the crime was committed, so we need to look at the specific counties. We have that information, so I think it'll be only a couple of DA's offices to refer to.
thank you, let's vote. Those in favor of the motion, please vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Ms. Smith?
Can she give us any idea, since there were so many of those cases, what was the crime that was being perpetrated?
So we had a series of companies that we were calling cloud companies that were popping up on the internet, and it depends. Most of the time they were impersonating real licensed individuals and saying, I'm Marcia Franks, I am trying to sell real estate, and that was not the case. So we had some complaints that were filed against the person, and they're like, no, this isn't me. And so we were able to trace them back to a few different companies, but we think they have different names, but are maybe possibly run by the same person. So that was what was happening, and that's kind of it's not only like a violation of unlicensed activity, but also like criminal impersonation. So we thought that the DA's office and the Attorney General would be able to do it, since we also don't know who those people are.
Okay, Ms. Smith, the first case you have is represent, where you're asking the commission to reconsider a previous decision with no new evidence.
Well,
Anyhow, I'm not trying to put you on the spot. Why don't you proceed with your case?
okay. I'll start with the number.
Okay.
Number 49, 2017 065. I'll do that one more time. Number 49, 2017 065 So you're correct, I don't have any new information, but it's after reevaluating this matter, I feel like I can explain it better to the commission, because I'm not really understanding where the violation is. So I thought that I could start with, well, I'll read my quote-unquote new information first. Council does not see a clear violation here and requests the commission reconsider the facts and discuss if necessary. There was also a complaint opened against the seller's agent and their principal broker. At the same time, this was opened along with the next one we're going to discuss, and those were both dismissed without any action. Basically, the respondent here is the buyer's agent. Or after the purchase and sale agreement was executed and closing happened, the buyers found that there were termites in an outbuilding on the property that they bought. The respondent and the sellers state that they did not know that a certain outbuilding wasn't inspected when the termite inspectors came out, and also then issued a letter saying there were no termites. So after everything was said and done, the buyers had the same termite company come out after they bought the house, and they then said, we'd never inspected this shed, this outbuilding. That was the first anybody knew of it. And then after that, all of those issues were resolved with the termites. I just don't see where that is the respondent's fault.
So, just out of curiosity.
Sure.
The consent agreement that we agreed to, did you send that to the respondent?
I did.
And so, did they give you any new information?
They didn't give me any new information, but we've discussed it at length. And after they made their argument, and there's been some time to consider it, I've had more experience, I just don't feel that there's a violation. I would have to litigate this because the respondent's not going to sign any consent order, and I understand why. And I'm happy to litigate it, but I thought it should be discussed before I move forward trying to litigate something that I don't feel there's clear evidence of a violation after a reevaluation and much
So the
discussion.
licensee was the person who was to contact the exterminator, right?
No, I would think the buyer and/or the seller would be the one to contact a termite company to come out and inspect.
But that's the question, who did? With this being against the respondent, is the buyer's agent?
The sellers had the termite company come out and inspect everything.
Except the outbuilding? Because you have to specify that.
They didn't know that the outbuilding wasn't inspected. And when the termite company came back out later, they said, well, we didn't put that in the letter. We didn't tell anybody we didn't. So it wasn't found out until after the house was purchased, when the company came back out and said, oh yeah, we didn't do the shed.
So they would have needed to say to the termite person, we want you to do the house, and we want you to do the shed, and we want you to do the barn, and whatever. And they did not say that. They just said the house, right?
I don't know what was said or what wasn't.
Unless you specifically say the sheds, they're only going to do the house.
I know the amendment to the purchase and sale agreement specifically stated all buildings.
Yeah, but termite inspectors usually don't see the contract.
Right,
But-
right.
But also, too, I find the opposite. I mean, I tell them to go inspect, and they just do whatever's on the property. They don't, I mean, they might call me and go, do you want me to do the barn? You know, but unless I tell them differently, they just inspect everything. So I don't know that, I guess I really don't have a problem, I guess, with your thought on what we should do. My concern is, where's this thing been laying for 2 years? I mean, how many other 2-year agreements are, I mean, I'm like, within a 2-year time period, if these people hadn't already done what we told them to do.
Well, that was done when I presented it. They had already resolved the issue when I first presented it.
No, but I'm talking about, I mean, we've given them a civil penalty and a 4-hour contracts class that they had to do within 180 days, and that's what we told them. So they just been saying no for a year and a half now?
I mean, I've been in communication with them, but obviously not often for the last 2 years. I mean, I guess we can blame that on me.
But they had 180 days, and they didn't respond within the 180 days.
Right.
They
Yeah.
have to agree to it.
They have to
That's
agree to
right.
it.
So, I mean, I could have set a formal hearing. I just have to triage my cases, and I was no longer on this commission. So,
We can take care of that problem. You can come back. We have an opening, we're here. I'm kidding.
so I'll take responsibility for the delay.
Priority order, triage is priority order.
Is that a legal term?
I mean, I guess when I've got a lot of cases that could need to be litigated, and when it comes to the safety of the public, and if there's an immediate danger, I choose to deal with the ones that have a more serious danger. And when I'm on another commission now, that there's quite a lot of cases that are, in my opinion, just more of an immediate danger. So I did the best that I could, and I apologize for the delay.
Well, don't do that, but let me ask you this. So the original complaint was a home buyer filed a complaint against his or her agent because his or her agent didn't ensure the barn got a termite inspection, or the outbuilding. Is that what it is?
Yes. And
Okay, that's enough.
Yes. So I believe the seller, though, was the one that maybe should have told, or the seller's agent should have told the termite company. I just don't see how this is on the buyer's agent.
You just don't know who was responsible for hiring them, though.
Well, both the buyer and the seller both said, well, it was the other person's responsibility. No, it was the other. And in the end, the seller came back and paid for that second termite inspection after the house was purchased.
Is this information the exact information that you gave us when we voted before?
Yes.
2 years ago.
Well, so, I mean, really it boils down to, should it,
He said, she said.
yeah.
I mean, our contracts pretty much state that all inspections are responsibility of the buyer, right?
Unless it's VA, then the seller pays for it.
Regardless,
And if they pay for it, do they also schedule it and hire the,
I think that who pays for it, usually the one that calls and orders it. Because then they'll say, okay, who am I going to send the bill to? I mean, I see that a lot, so.
Sent to the realtor.
I mean, I got a hard time pinning it on the agent.
I know.
I mean, if I was going to pin it on somebody, I might pin it on the termite company, but
when you don't want them to, they find a stack of logs and find termites, right?
they find it in the mulch all the time.
Yeah.
So
So you want to accept council's recommendation, move on?
I'll make that motion.
Is there a second?
Second it.
All right, Mr. Bagley seconds Mr. Wood's motion to
Is
accept
it
council.
dismiss or letter of warning?
Oh, what did you put?
I'm
saying just dismiss it.
Are you okay, Joe, with the dismissal?
Because the second one is dismissed.
Okay, the motion is to accept council's recommendation and dismiss complaint number 49. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you for your good advice, Ms. Smith. I don't want to be part of a triage if I can help it. All right.
So, number 50, 2017-065101, this respondent is the principal broker to the affiliate broker that we just discussed. So, my same recommendation of dismissing it for the same reasons.
Move to accept council's recommendation.
Second.
Motion by Ms. Franks, seconded by Mr. Wood. The council's recommendation be adopted and case number 50 be dismissed. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, what do we have on 51?
51 is 2018-044-991. And the new information, the respondent had originally agreed to sign the consent order when I sent it out. We gave the respondent an extension while they still had an active license. And then respondent's license expired on September 3rd, 2019. There's been no attempt to renew their license. They stopped talking to us and communicating with us even when we've reached out since they agreed to sign that consent order. So considering respondent is no longer an active agent, I request that the commission close and flag the complaint. So if the respondent ever did try to come back and renew, they would have to come before you for any kind of approval for even to get their license again. So yes, my recommendation would be to close and flag.
Second.
Yes, makes a motion to accept council's recommendation. Mr. Begley seconds that motion. Discussion. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 52.
2018-025-431. Council has been unable to locate or secure any kind of service upon this respondent, which is an LLC. There's been no further complaints filed against this respondent since it was opened in April 2018. The matter was also referred to Consumer Affairs when it was referred to us and it was first opened. I guess the Consumer Affairs had a history with the respondent at that time. But because we've not been able to secure service and they're unlicensed, I would recommend to dismiss this complaint, or we can close and flag it. I just didn't think that that would be helpful, considering they're not a licensee. And their website has been down since the complaint was filed. There's no kind of information when I Google them. They're just not in existence anymore. So I just don't feel like any kind of unlicensed activity is still occurring. Therefore, I thought it would be better to close it than litigate it.
Did you check with the state about the LLC?
The LLC's been inactive since 2017.
Move to accept council's recommendation to dismiss.
Motion by Ms. Frank, seconded by Mr. Diaz. The council's recommendation be adopted and this complaint be dismissed. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 53.
2018-039-271. Council has been unable to locate or secure service upon this respondent, and there's been no further complaints since this matter was opened in June 2018. I also found something new since I typed this. The respondent was recently acquired late last year by a travel apartment company that bought all of their assets. So the respondent is definitely no longer engaging in unlicensed activity. They're not around anymore. So my recommendation, for the same reasons as the last one, would be to close this.
Move to accept council's recommendation.
Is it closed or dismissed? Close and flag.
The same thing. Close and flag would be different than dismiss, but dismiss and close are the same thing. So I apologize for that. Dismiss.
So your recommendation is to dismiss?
Yes.
The motion was made by Mr. Beckley, seconded by Mr. Diaz. Is there discussion? Those in favor of that motion vote aye.
Aye.
Those opposed vote no. The motion passes unanimously. What else, Miss Erica?
That is everything I have today.
We
Good to
appreciate-
see you.
Good to see you too.
It's like a guest appearance. You know, you just
Yeah.
drop in for.
You'll be seeing me soon because I think I've got 2 things I'm going to be litigating.
So we didn't eat all your brownies or your biscuits.
I think you should take them with you because I've had enough.
Well, maybe staff would like to have them, but we'll make sure.
Yes, staff, please go enjoy brownies and Jim and Nick's cheddar biscuits.
Thanks
No
for
barbecue,
thinking.
though.
No barbecue, but,
I thought it was too early. I thought this would not run as long. I should have brought that.
all right. Anna, anything else to come before the commission from your perspective?
For the legal
We have a legislative update.
Yes.
Thank you. That's what I was looking for.
So we've had a couple of bills that have been filed this legislative session. There are 2 in particular that if passed may impact this commission. One of them would be House Bill 1619. This would provide a new exemption into Chapter 104 that would exempt housing authorities from obtaining real estate licensure. The next piece of legislation is Senate Bill 1595. This would directly impact 6213-313A2. So this would increase the amount of time that a respondent has to respond. Currently, statute says 10 days, and it would increase it to 30 days.
Do we care about either of those? We don't care about housing authorities not having to have a license, right? That's not a big deal.
I'm just,
Tennessee housing authorities? Or?
so it's like housing
We have
authorities.
local housing authority
We
in
have
Franklin.
local and state housing authorities, and this would just be an exemption that they're not required to be licensed. And then the next one, these are just 2 that directly impact the commission.
Those housing authorities not getting licenses, is that typical in other states as well, or?
I'm not sure, but I know we do not currently license them now, so.
Oh.
And are they just leasing or are they selling? They're just leasing, aren't they? Housing authorities?
Correct, so they're not, so if you look at the definition, you have to buy, sell, or lease for a commission or fee, and they're not receiving a fee or a commission from that.
Low-income housing.
And we typically, historically, we have not licensed housing authorities, so it's not like we would be, I don't foresee a change from this particular exemption.
Was it just to codify it in statute that they don't need it? It's just,
Correct.
okay.
So, another topic, I understand that Tennessee Realtors has talking points to go over with legislators on the Hill tomorrow related to out-of-state brokers coming to the state and affiliating with companies that are licensed in Tennessee so that they can do business. Have you heard of any of that?
It's called portability.
Well, it sort of is.
Yeah.
But they're going to talk about it, but it doesn't sound like it's been filed as far as I...
We don't have anything that's been filed at this time, as of today. So it may be in the future, and if that happens in the future, we'll treat it as any other bill.
It's a huge movement, though, Canada and the United States.
Well, I'm kind of for universal licensing myself, but that's not what this is so much as it's just getting somebody to be able to work legally inside the state. All right, Caitlin, what's new? What do you have for us?
Nothing additional.
Do you have our plaques?
I do,
Thank you.
right here.
Ross, anything?
Nothing more today, Mr. Chairman.
So one thing I'd like to do, I bragged on Aaron personally when I was talking to him the other day. Mr. Smith, other than the fact you haven't shaved lately, I think you've been doing a heck of a good job as far as getting our expenses reimbursed in a timely fashion, and it appeared to me today you're working to make it even quicker. So I want to thank you for that. All right, any last words from anybody on the commission before? Those who are going, our next stop is 2 o'clock at the downtown Hilton, which is near Bridgestone.
Ross has offered to drive anybody that would like to be
Good man.
driven.
Okay, perfect.
I'll just point out that today, when we've been here, we've had the 3 smartest real estate agents in the state that have come to this meeting because they knew that we had to be somewhere today, and they knew they could come and get 8 hours of credit, and it would not be here for 8 hours. So Bob's story, and he's got 2 people with him, and so there's the smartest 3 agents in Tennessee today. So
What about the people on the panel? Where would you put them as? Smart or the?
which ones?
Take these 5 right here. Would you say they're the smartest?
Oh, we're kind of in a different category. I mean, that's
All right, if there's no objection, then we're adjourned. Thank you for your participation and professionalism.